Please rise. Justices of the Appellate Division, Supreme Court, First Department. He, all persons having business in the Appellate Division. You are here, in your attendance, and you shall be heard. Please be seated.
Welcome to the Appellate Division, First Department. We have almost 7.5 hours of argument time requested. Therefore, only ask for the time you need. We are familiar with the briefs and the records, and if we have more questions, we will continue to keep asking them. People versus Barry. Appellant? Respondent? Submitted. Fuiz versus 6 East 72nd Street. And if everyone could identify themselves as they ask for the time.
Plaintiff, appellant, respondent requests 6 minutes plus 3 to reply.
Okay? You're not the first appeal, though, right?
Yes, I am the first appeal.
Okay, that's not how it was teed up. Okay, so you're going to be arguing first?
Yes.
Okay. Okay?
Respondent, appellant, Joseph K. Blumko and James J. Blum. 5 minutes, please.
And do you want any rebuttal time?
2 minutes.
Okay?
Third-party defendant, appellant, respondent, Roberto Ltd. 5 minutes, please, and 2 for rebuttal.
Respondent Ronson, 4 minutes. Respondent for 6 East 72nd Street Corporation, Board of Directors for 6 East 72nd Street Corporation, and the property manager nominee act. I respectfully request 5 minutes and 2 minute time rebuttal, please.
You don't have an appeal, though, do you? Okay, so you don't get rebuttal time without an appeal. Okay, so plaintiff, 5-1, Bloom, 5-1, Uberto, 5-1, Co-op, 5, and Ronson, 4. R. Lavender is submitted. Shaw versus 20 East 64th Street, appellant?
Appellant, Urban Foundation Engineering, requests 5 minutes and 2 for rebuttal.
Respondent?
2064th Street, I'm DJ sponsor from Mr. Connor, August 21st, 2023, request permission for the argument.
The application is granted. Okay, 5-1 and 5. Jones versus State of New York, appellant? Respondent? 5-1 and 5. People versus Louis Chacon, appellant? Respondent? I'm sorry, how much? 6, 2, and 6. Hemingway Group versus I-80 Group. I know that there are 2 appeals. Because we have a very long calendar, I'm going to put them both together, even though I know they're discrete issues. Appellant, respondent?
I-80 appellant, 6 and 2. Or respondent, I-80, respondent, Hemingway Group 8.
Do you want to break that up since you have an appeal too? You'll make it,
I would say that the 8 would be the response to the first appeal, and perhaps.
but everything's going to be heard together. So it's up to you whether you want rebuttal time also, or you'd rather just have it all together.
It's almost like 8, 2, and 2, or 8, 3, and 2.
No, you're only getting 1 rebuttal time. Okay, that's okay. It's 6 and 2 and 6 and 2. And that, you should argue both appeals together during that time. Schneiderman versus Brand, appellant? Respondent? 4, 1, and 4. People versus Johnson, appellant?
Appellant requests 6 and 2 years.
Respondent? 5, 1, and 5. Rappaport versus Nye, appellant? Respondent?
Respondent, lighting collection, Thomas Kaplan, and Yvonne Tunin, request 5, Your Honor.
Respondent Roger Landau, Nathaniel Landau, Stephen Landau, respect to request 4 minutes, Your Honor.
I'm going to give you 4 and 1, 4 and 4. Bradby versus Structure Tone, appellant?
Appellant requests 8 and 3, Your Honor.
Respondent?
Respondent, 6 minutes, please, Your Honor.
5, 1, and 5. If I was granting everyone the time requested, we'd be here till about 8 o'clock tonight, so there's no way. Wagner versus New York City Department of Education, appellant?
Yes, for Appellate Wagner, Your Honor, requesting 6 minutes and 3 minutes in rebuttal.
Respondent?
Respondent requests 5, Your Honor.
What are you standing for?
I'm Wagner, the NYC Department of Education.
I'm sorry, I only think there's 2 parties in that?
Should only be 2 parties.
What?
You're with the city? I'm with the city, respondent, New York City Department of Education.
Wait, who are you with?
For Ms. Wagner.
And who are you with?
I think it's a different case. It's Mr. Jim Wagner. Is the appellant.
I'm sorry,
It's okay. Wrong Wagner.
so is this not your case? Okay. 5, 1, and 5. Tamara Equities versus Signature Barbershop, appellant? Respondent? 5, 2, and 4. People versus Signuis, appellant? Respondent? Submitted. Vignali versus City of New York, appellant?
For the appellant, 5 and 3, Your Honor.
Respondent? 4, 1, and 4. RC versus City of New York, appellant?
Appellants 5 and 3.
Respondent? 5, 2, and 5. And KPP 3 versus Douglas is submitted. I don't know if you're not on the calendar for today?
It's the same caption, but it's a different case number.
Okay, so it must have been an error, okay. Okay, People versus, oh, that's submitted, sorry. Fleas versus 6 East 72nd Street. Your times are running.
Thank you. Good afternoon, Your Honors. Thomas P. Higgins of Higgins and Trippett, LLP, for the plaintiff, appellant respondent Beverly Fuse, suing individually and also on behalf of the estate of her deceased husband, Robert Fuse. The first issue I'd like to address is the dismissal below of the plaintiff's claim to enforce a contract to which she was not a party. That dismissal.
Then let me ask you about that, because there seems to be a very, very clear no third-party beneficiary provision in the contract. Why should we not enforce that unambiguous, clear provision which says there will be no third-party beneficiary?
Well, Your Honor, because the law in New York is clear that a party can nevertheless enforce a contract to which they are not a party in the
Never
face of a
what?
third, to which they are not a party in the face of a no third-party beneficiary clause, if the contract grants substantive rights to that party.
But
We
the
cite-
contract
Where in the
grants,
contract does it-
go ahead, please.
Where in the contract does it grant substantial rights to your client?
Yes.
Not generally to people in the building, but to your client?
Well, my clients are shareholders in the cooperative, and under Section 22 of the alteration agreement, which is the contract we seek to enforce, the shareholder has expressly agreed to indemnify and hold harmless the corporation, directors, officers, and shareholders. There is an accompanying letter, indemnification letter, that is also part of that alteration agreement, where shareholders, which includes my clients, are identified as indemnified parties, which is a defined term. They are also identified in the alteration agreement as adjacent shareholders. They own an adjacent apartment. The co-op, my clients own a duplex on the first 2 floors, and
In cases where a person who is not a party to the contract and seeks to prevail despite a no third-party claim provision in the contract, there is a specific mention of that person in the agreement. There is no such specific provision regarding your client, correct?
Your Honor, in the Diamond Castle case, which is this first department from 2011, a private equity deal, there was a no third-party beneficiaries clause, but the party was allowed to sue because they were in the class of people that were indemnified. They weren't identified by name, and I think the same is true in the MPEG case, also decided by this court in 2018, and in the Dormitory Authority case of the Court of Appeals.
Doesn't the agreement, in fact, give you the ability to sue Ronson for damages as opposed to the co-op?
Well, that's one of the parties that we have sued. Our first,
Right, but this is a negligence claim we're talking about. It's not a contractual claim.
well, we have a negligence claim too, but we did have our first cause of action was for breach of contract, and our eighth was for specific performance of the contract, and the court below dismissed those claims. And it's interesting because the decision below, the judge says, well, the Fuses can seek indemnity under the alteration agreement, but how can we seek indemnity if the contract claim is dismissed? We've sued Mrs. Ronson for indemnity. We've sued the co-op for a variety of theories. We want to enforce this contract that mentions the category that we are in as shareholders, and we're left without any recourse. And as the Court of Appeals said,
Don't you have a recourse against the entity which actually caused the damage, which is Uberto?
well, that's a separate issue. We did not name Uberto directly. We sued Myrna Ronson, and that negligence
Why wouldn't you
claim
have a claim against Uberto, which is allegedly the entity which caused the damage?
Well, because Mrs. Ronson was expressly agreed to be responsible, both in the alteration agreement and under the proprietary lease, to be responsible for any damage or harm that she caused to adjacent shareholders.
Counsel, say we disagree with you and think you're barred by that provision in the contract. Do you still have a fiduciary duty claim against the board?
We do, Your Honor, and that was dismissed based on the business judgment rule. And our argument there is that the business judgment rule under Lewandowski, which we all are familiar with, people who practice in this area, nevertheless doesn't apply if a cooperative doesn't follow its operative governing documents or contract to which it was
You'd have
party
to, but you would have to identify a duty that's separate from the agreement, right? Like a separate duty that the board has to your client.
We have. We refer obviously to the alteration agreement to show the level of control and duty that the board undertook, the co-op undertook, but our claim, the fiduciary duty claim, was a separate claim, and that was dismissed, and we think that the business judgment rule should not protect a board that refuses to enforce the terms of an alteration agreement.
Thank you. You'll have time on rebuttal.
Thank you, Your Honor.
May it please the court, my name is Martin Schwartzberg. I represent the Blum defendants. My appeal focuses on the lower court's denial of the dismissal of the negligence and nuisance claims against my client. With respect to the negligence claim,
Why isn't there an issue of fact with respect to Bloom's involvement in contributing to the damages based on the role it allegedly played in reviewing the plans and advising the board as to the plans?
And also, let me just add to that, and also its role in allegedly supervising the work done by Uberto.
all right, I can address the supervision question very quickly. Uberto, the general contractor, in its contract specifically provided they were responsible for direction, supervision of control, means and methods of construction, hiring a competent superintendent, protecting adjacent properties from damage. I don't have a written contract. My agreement was with the board. There is no written contract. They were an on-call engineer to review the plans for the proposed renovations. Plaintiff's own reply brief says it's undisputed that Uberto is the one that caused the vibrations causing damage to the
Right, but there can be contributory causes, and if there's a question of fact as to whether the role that Bloom plays contributed to causing the injuries, that would be a basis for the claims to go forward. So how can we say as a matter of law that the role Bloom played in allowing these plans to be improved and in allegedly having some involvement in the work didn't in some way contribute to to the,
Their role was to make recommendations to the board. It was the board that ultimately approved the renovation plans based upon my client's recommendation. However, and that goes to one of the arguments I'd like to make, and I made to the court below, is I submitted an affidavit from my client, a licensed professional engineer working for a professional engineering company, that says he complied with the general customs and standards and practices in the industry in the state and city of New York for licensed professional engineers providing services such as the ones that were provided here.
But counsel, then we also have the affidavit from Crosby, which indicates that Blum personally reviewed and supervised, excuse me, I should say, instructed the workers. So we have competing positions here.
Well, first of all, Mr. Crosby is not a licensed professional engineer. The case law is clear that if you're going to oppose a motion by a licensed design licensed professional, you have to have a licensed professional engineer or architect oppose the motion. The Heimer case.
So you need a licensed professional,
professional.
to say,
Comment.
no, I'm still speaking, thank you.
I apologize.
It's okay. To say that he personally reviewed and oversaw the work, you need a licensed professional for that?
Well,
That's a factual issue.
no, with respect to a professional standard of care, licensed professionals have a higher standard of care. That's why they have licenses. That's why they have to go through training and take tests. So if you're going to say that my client, same with a doctor in a medical malpractice case, they're another licensed professional. If you're going to say that they breached a standard of care, it's a professional standard of care, and the person saying that has to be a licensed professional as well, with the same requisite training and experience to render that kind of opinion. My client did not, supervision and construction has a very specific.
you know, you're mixing up two issues though, because one issue is supervision and one issue is your involvement in approving that. And a layperson can understand that without having engineering expert testimony, whether or not there's an issue as to whether you failed to adequately advise the board as to the wet over dry issue.
Well, and that goes to Mr. Blum's prior experience with at least 12 prior renovations at this building. He knew that the building approved wet over dry installations on a regular basis. He put in his letter of...
Isn't that a factual dispute about, and that's one of the main issues in this case, what the building's practices were or were not with respect to wet over dry?
Well, I don't think there's no...
I mean, because the rules said no wet over dry. So the question is, isn't that a factual issue, whether or not they were following the rules and whether you were required to advise them to follow the rules?
But the board ignored those rules on a regular basis with regard to wet over dry. There were prior installations of powder rooms, such as the one that was put in the Ronson
I'm
apartment.
sorry, so are you saying that your client's obligation was to take into consideration what the co-op ignored in other cases? It seems to me that's not within the scope of what he as a professional is supposed to consider, is it?
Well, that again goes to the professional standard of care and what licensed engineers would have done in similar circumstances. And again, they didn't have that here. They didn't have a licensed professional say.
Thank you. Thank you. You have time on rebuttal.
Good afternoon. James Divany for the third-party defendant, appellant, respondent, Uberto. We're simply requesting that the court reverse the decision of the court below that granted contractual indemnification and attorney's fees.
Well, let me ask
for
something.
Ronson.
At the heart of that claim has to do with whether or not there's any evidence in the record that Ronson was negligent. What evidence is there in the record that you can point to that raises an issue of fact as to whether Ronson was negligent in any way when it's undisputed she was in Europe while these renovations were going on?
Yes, Your Honor, but there is evidence in the record that she was there when the project began. She wasn't in Europe yet.
Can you point us to that?
I don't have the citation, it's in the brief.
Okay.
When she was in Europe, she was in contact with the project manager, Rebecca Caratanudo, twice a week. She had her son as her proxy present throughout the alteration project. That was Stanley Shashua. He got involved, numerous emails. He tried to limit the scope of what the independent engineer that was hired by the building, but what their role was going to be. He requested that Ms. Fuse be barred from entering the apartment. He was going to call the police. The family was very involved. And I believe that there is a question of fact as to whether they supervised and controlled the project, and they have not demonstrated that they're free from negligence. But the second point is that the indemnification agreement that's relied upon by Ronson in her papers in the court below violate the general obligations law.
Well, it only violates, go ahead.
Well, I'm going to make the same point you were.
It only violates the general obligation law if there was negligence on her part. If we find that there's no evidence of negligence, it doesn't violate it, so the two issues go hand in hand.
Okay, but the saving language is not in the contractor indemnification agreement that goes with the alteration agreement. The other point I'd like to make is the court below did not identify which causes of action by Beverly Fuse against Ms. Ronson Uberto is responsible to indemnify Ronson, if indeed Uberto is. We believe that it would only be for the property damage claims, not for all the other causes of action asserted by Fuse against Ronson, which would include the breach of contract, specific performance, nuisance, and conversion claims. It's clear from Ronson's papers and the third-party complaint that they were contemplating indemnification for damage to the Fuse apartment and personal property based upon the 4 incidents that occurred and not for the other causes of action.
Okay, thank you.
All right, thank you very much.
May it please the court, my name is Rosalie Stilatana with the law firm Boyd Richards for the 6 East 72nd Street Corporation, the board of directors, and the property manager, Gumley Haft. The
Let me ask you a question about the breach of fiduciary, not breach of fiduciary duty, the business judgment rule issue and the breach of fiduciary duty. Why shouldn't the claim for breach of fiduciary duty go forward on the ground that there's evidence in the record that the co-op did not follow its own rules about which alterations should or should not be allowed in terms of the wet over dry issue, which seems to be one of the predominant issues in this case?
Respectfully, Your Honor, the Lewandowski case controls here because the judicial scrutiny shouldn't be involved in the wet over dry issue. The board relied on the Blum engineers to approve the wet over dry installation, but also taking a step back.
There's an express rule here in your own rules that you're not allowed to have wet over dry. So whether or not you relied on any other advice, isn't there an issue by not following your own rules? Does that create an issue of fact as to whether you've given up the protection of the business judgment?
Respectfully, Your Honor, the original floor plan for this building, as testified by Blum in the record, demonstrates that pre-existing conditions for the original floor plans in this building has wet over dry and noisy over quiet spaces. That is the floor plan for this building that was pre-existing. That's exactly what Ms. Fuiz bought into when she submitted to this.
Even if that was pre-existing, the board could still pass rules that they will not approve any alterations that don't meet those criteria. So the fact that that happened was pre-existing doesn't vitiate the force of those rules or the fact that the co-op violated them, does it?
Well, I don't believe that there is an express rule for no wet over dry because there was precedent in this building to allow at least 12 different alterations that had wet over dry installations. And that was a precedent that the board relied upon with the expertise of the Blum defendants, and that appears at the record 2616 and 2617. And the board, in terms of breach of fiduciary duty, we respectfully request that the breach of fiduciary duty claim remain dismissed because the board did take active steps here. Once the first complaint was made by Ms. Fuiz, the board completely shut off the riser valve that was in question.
The rider to the contract between them said no changes to the apartment's layout resulting in wet over dry rooms, noisy over quiet rooms will be approved.
You're saying there was no rule, and she's asking you, what about the rider, which has a rule?
Well, in this particular instance, you know, each
Why doesn't
individual.
the rider create an issue as to whether or not you're entitled to the business judgment rule because you didn't follow your own rider?
Because there was precedent in this building already for the board to make these decisions because of the peculiarities in this building, which is also a tenet of the Lewandowski case, which is that the board is in a very particular situation to be able to understand the peculiarities of this building. And here, the peculiarities of this building is that there was already pre-existing conditions in each of the apartments for wet over dry. So even
aren't
if
there
there's a
cases-
conflicting...
Aren't there cases, though, which hold that one of the grounds in which the business judgment rule will not apply is where a co-op doesn't follow its own written rules?
In the cases that the appellant cites to you, it wasn't specifically about the board not following the rules, but it was more about self-dealing. For instance, there was a board member in one of the cases that had expressed financial benefit because they were a broker on the deal. And so here, nobody on the board, everyone is a volunteer. Nobody entered into any self-dealing. There was no self-dealing or any benefit to the board in providing a routine alteration approval and entering into a routine alteration agreement, especially when the pre-existing conditions in the building already had wet over dry, and there was ample precedent for other apartment owners who made similar alterations. And the board took active steps once there was a complaint to investigate. They shut off the riser valve. They hired an independent engineer to conduct a review and thorough investigation, which was the Haffey report that's at the record 2462. And based on that recommendation, the board allowed the alteration to move forward.
Is Lewandowski concerned only with self-dealing or more generally with any abusive exercises of the board's judgment?
Well, I think Lewandowski is very similar to this case in that it also involved a renovation, and it was testing whether or not it was reasonable for the for Lewandowski to enforce specific performance to have a riser moved. The board took the position that the riser should be placed in its original position, and initially the first department found that it was reasonable to let Lewandowski have the riser removed. But on the Court of Appeals reversed that decision because it said it's not a test of reasonableness. It's not about whether it could be, found with merit. It's about what the board wants to do for this particular building.
Thank you. Thank you.
Excuse me, may it please the court, my name is Loretta Redmond. I am here for Myrna Ronson as respondent. I can provide your honors with some citations to the record where Alberto themselves admitted that they determined what tools were to be used, they were responsible for safety, they did the work. Ronson did not know what work was being done. She did not tell them what to do specifically. She was not a plumber. She was not an architect or an engineer. If you refer to 2424 to 2427 for Alberto's testimony and 646 to 6449, 6446 to 6449 for Ronson. In regards to the third-party beneficiary argument, we believe that that part of the lower court's order should be affirmed. The one case that was referred to, I believe, by Alberto Musk is a lower court case, and in that case, it is distinguishable because it was conceded that the indemnification applied therein. That is not conceded here. We believe, it's been our position consistently, that it is for the board, the co-op, to enforce the alteration agreement. There's a reason for that. You don't want arguments going on between two different co-op owners, and that's what started to happen here. There was a reference about barring Mrs. Fuse from the apartment. That was because she began to be very aggressive. And so you want a board to be there to mediate. They put in an alteration agreement so that there's rules in place, and Ronson followed what she was told to do. If there's no other questions, I will rest on my brief.
Thank you very much.
Thank you.
Here, plaintiff, appellant, respondent, just rebutting. In 2008, this board adopted as a rule and regulation a comprehensive alteration agreement. And in that alteration agreement, it said no wet over dry without express written consent and no expanding a bathroom unless you have specific prior written approval. They didn't do that in this case. It was their rules, it was theirs that everyone had to follow. Now, they're here to try to justify both below and before this court that, well, in 1929, when the architect built this building on Fifth Avenue, that there was wet over dry. But that series of facts, even if it was in this record in permissible form, and it is not, is hearsay. It shouldn't go to how you construe a document that was adopted in 2008. And that's what they're trying to do. Say, well, we didn't follow our own rule, but the business judgment rule should apply, and we shouldn't be found in breach because there was other examples of wet over dry. And as I say, the construction of that contract is the province of this court, and those extrinsic evidence of supposed wet over dry shouldn't militate against that. One more point, or should I? Am I done?
I'm sorry, what? Yeah, you're done. I'm going to try to stick with the time today. Thanks.
Just a couple of quick points. On the express written consent, I would respectfully direct the court to page 2301 of the record. There's a letter from Gumley Half, the managing agent, to the board of directors that was countersigned off by one of the board with respect to the installation of the powder room. So there is express written consent in the record at 2301. And with regard to the comment concerning the bathroom, the bathroom had to be extended because to comply with ADA standards. Where the water was, the toilet and sink in the bathroom when it was expanded remained in the same place. So even though the bathroom was expanded, the water remained in the same place it was before, and the expansion was only required to comply with ADA guidelines.
Thank you.
Uberto, in rebuttal briefly. When Ms. Ronson was asked at her deposition upon written questions if she directed any portion of Uberto's work, she said she didn't remember. She didn't deny it. She said she didn't remember. Also, paragraph...
She did.
I'm sorry?
That doesn't establish that she did supervise it.
Doesn't establish it, but she did not affirmatively say, no, I did not direct any portion of the work. Also, the alteration agreement, paragraph 4, Ms. Ronson accepted sole responsibility for the work. And that alteration agreement dictates various things, such as when the work begins, when it ends, the
Counsel,
work
did
hours, the
anyone
tools
from
that are used.
Uberto put in an affidavit saying this is what Ms. Ronson or her son did with respect to supervising us and our work? Was there any factual statement from your client about that?
There isn't. He said he supervised the work generally. That was his testimony.
That he supervised it, or that who did?
Mr. Crosby, who is the principal of Uberto.
Right.
Thank you.
Thank you.
Shaw versus 20 East 64th.
Good afternoon, Your Honors. May it please the Court, Eric Leiter of Morrow Lilling Party for the appellant, Urban Foundation Engineering, LLC. The relief granted to 20 East should not have been granted because the motion was improper. It was prohibited by 4405 and 4406.
Well, let me ask you about that, because what post-judgment relief was actually being asked for in this case, as opposed to asking to just include effectuating an earlier decision about contractual indemnification?
It was asking for a determination of the scope of contractual indemnity obligations, among other issues.
Hadn't that already been determined? Hadn't a conditional indemnification order already been put into place, which said whatever the allocation was at trial was what the indemnification was going to be? So what determination needed to be made post-judgment?
So that determination had not been made by Judge Kotler, and that was the finding of a similar finding by this court when Judge Kotler granted conditional common law indemnification, and 20 East argued that that meant it was entitled to common law indemnity of everything, and this court held no, it was not. There was a post-trial motion that addressed what the scope of that conditional award would be. It was determined by the court by that post-trial motion, and this contractual indemnity claim needed to be resolved the same way because the contract provisions and even the admissions made by 20 East when it obtained the conditional contractual indemnity award.
But why isn't it
specified.
just a simple mathematical equation? They were allocated 40% of the responsibility for the accident, so they had to pay 40% of the damages.
If it were that simple and that's what the judge had done, we may not have this appeal, but the judge ordered that what Urban was going to be liable to 20 East for is 100% of
Right,
not
but
only...
that's a different issue, whether the court got it right or wrong. It's a different issue than whether the court was issuing post-judgment relief.
Yes.
And that's another part of your appeal. I understand that the court shouldn't have done 100%, it should have done only 40%.
Correct.
But that's a separate issue.
Correct. The two issues are, first, that procedurally, the statutes say it's improper, and this court's holding in DeMetro indicate that it's improper to permit a subsequent post-trial motion when there's already been a post-trial motion. And here, unlike DeMetro, where it's only made 2 months later, this was made 2 years later after there's already an appeal taken, in which they made some of those arguments on that appeal. And so to allow any party to go back to a trial court after they've reached this court and received a decision they didn't like on their post-trial motion really defeats the purposes of 4405 and 4406. And so we say first and foremost that procedurally the
So you're
motion should
suggesting they
not
should
be
give up
admitted.
their right to contractual indemnification even though court ordered that they get contractual indemnification?
I
Is
think
that what you're suggesting that we should do, allow them to, that they waive their right to get any contractual indemnification in this case?
I think it would be appropriate here to find that they waived and to understand why they would have waived. That because, as we've just discussed, what they would be entitled to as contractual indemnity from Urban would be no more than 40% of the amount of the tort damages. That by seeking common law indemnification, they were already seeking 100% of the tort damages. So there was reason for them not to make an application to receive 40% of of the award when they were already going to receive 100% of the tort. It's only after they didn't get what they wanted by not getting 100% through common law indemnity of all of the damages, including breach of contract damages, that they went back to the court and made an argument for the first time that what they were entitled to under contractual indemnity was 100% of everything. So that's the problem, that they made a choice. They chose not to pursue that for the clear reason that what they were actually entitled to on contractual indemnity was less than they were already going to be able to receive from common law indemnity.
What
Then after they
evidence
lost
is there that they, as you must show, that they intentionally waived a known right? Like, where does that show up in the record?
So in the post-trial motion that they filed back in 2019, we noted in our opposition to that motion where they sought common law indemnity that they had abandoned their claim for contractual indemnity. And they did not dispute that.
They
And then
never stated that they were waiving their contractual indemnification claim, as far as I could see. Where did that, give me record evidence, like,
Yes, Your
chapter and
Honor,
verse, counsel. Where do they say that?
I'll try to identify that in the page for you.
Thank you.
For the rebuttal. But we did assert that in the post-trial motion papers that addressed the common law indemnity post-trial motion. And then there was also, on multiple appearances before the judge, subsequent to those filings, when the 20 East attorney was specifically asked whether or not it was waived, they said they wouldn't concede that it was waived, but they didn't have any reason, they couldn't answer one way or the other. And
Thank
that's
you.
certainly not an
You
assertion.
have time on rebuttal.
Thank you, Your Honor.
May it please the court, John O'Connor from Steptoe and Johnson for respondent 20 East 64th Street, LLC.
What about the argument that it was an intentional ploy on your part not to pursue the common law, not to pursue the contractual indemnification because you wanted common law, and as a result of waiting to this stage in the litigation, it's too late?
There's no basis to that, Your Honor. 8 years ago, my client received conditional contractual indemnification. The condition was satisfied, and so when it came time to reduce all of the trials and the rulings in this case to a final judgment in early 2022, we came in and said, don't forget, we have summary judgment on contractual indemnification. And Justice Cohen, who knows the unorthodox procedural path of this case better than anyone, he recognized that this was consistent with the way the parties had litigated the case, that He didn't think it needed a motion at all. You could have done this with letters. We could have just raised our hand and said, don't forget that, Judge. That's got to be in the final judgment.
Your
This was,
position, no post-judgment relief was really being sought in this case.
That's-
You just,
we weren't trying to undo the trial. The trial had reached a result, and we didn't have any quarrel with the results reached in the final trial in the case. So
The result, however, included an allocation of negligence liability, right? 40-60.
it
So
did.
why
Your
are you
Honor.
entitled to 100% from them?
Because common law indemnification involves equitable principles. This is contractual indemnification, and our contract, Urban agreed to indemnify 20 East to the fullest extent permitted by law. This is at A107 for any claims, damages, losses, and expenses arising out of or resulting from performance of the subcontractor's work under this subcontract. And then it goes on, and it closes with, regardless of whether or not such claim, damage, loss, or expense is caused in part by a party indemnified hereunder. So the indemnification clause at A107 specifically contemplates the possibility that there could be more than one negligent party, and we are still entitled from Urban to full indemnification for any damages, losses, or expenses arising out of Urban's work. The other indemnification clause is at A98, and it requires Urban to indemnify for each and every claim, demand, judgment, damage, liability, cost, expense, or loss of any nature, there's a parenthetical, and then caused by, arising from, or in any way incidental to the performance of the work hereunder. These are exceedingly broad indemnification clauses. And so this is not a common law indemnification that's grounded in equitable principles. We're entitled to the enforcement of the contractual agreements that the parties entered into here. I do want to touch briefly on Urban's argument, not mentioned in oral argument, that this is somehow covered by property insurance. It's not. This is a third-party liability. The Shaw's...
Right, the property insurance just covers your property, not the Shaw's property.
That's exactly right, Your Honor. And the funny thing is, the two policies that are in the record that are mentioned on the checks that were written for the Shaw's, neither one of them provides even $1 of property insurance to 20 East. One of them's a strictly liability policy, and the other one provides property insurance for one property, but not for 20 East, which only has liability and medical expense coverage under the policy.
thank you.
Thank you, Your Honor.
Thank you, Your Honors. Justin Moulton, I would ask that I be permitted to submit to the court a letter citing the exact page, but I can refer to the court that within the briefs, in the record where we submitted there's copies not only of the opposition to the original post-trial motion that contains our assertion about it being abandoned, but also in the motion papers to the court below we raised
I
that.
recall it was in the briefs. There was a back and forth about it. I just
We
didn't
can
find
look at the record. We don't need a letter from you.
So what I wanted to address, though, briefly was first, in terms of the scope, 20 East even conceded when it made the motion in front of Judge Kotler that the amount that it would be entitled to in contractual indemnity would depend on the percentage of fault assigned to Urban. That's page 632 of the record, where this is 20 East saying, whether and how much indemnification Urban owes to 20 East will need to await a determination at trial as to whether and how much Urban was negligent. It wasn't just merely whether or not they were negligent, but how much. Also on the issue of whether they ever agreed to, I'm sorry, but I see my time is out, unless the
You
court
could
would.
finish, yeah, okay, thank you very much.
Thank you, Your Honor.
Jones versus State of New York.
Good afternoon, Your Honours. May it please the Court, Prashika Raj for the appellant. Your Honours, Damien Jones spent over 5 years in jail for a crime that he did not commit. The only crime
How
that was...
do we know he didn't commit it? Because what we have is that there was a reversal by the Court of Appeals based on legally insufficient evidence, but the law is very clear that a reversal of a criminal conviction does not establish innocence. So how can we decide on this record as a matter of law that he was innocent?
Yes, Your Honor. Mr. Jones has submitted affirmative evidence that he did not commit enterprise corruption, and that's his affidavit and his deposition testimony, where he consistently denies that he had knowledge of or intent to participate in an enterprise.
Right, but why shouldn't, the criminal trial is not going forward because there wasn't enough evidence, but why shouldn't there be a civil trial to determine whether or not he was innocent, which obviously has the lowest burden of proof than a criminal trial, to determine whether he was involved in the enterprise?
Well, Your Honor, because not only is there that affirmative evidence, but the evidence at trial did affirmatively demonstrate that he did not have the mens rea to commit enterprise corruption. And so together, along with the fact that the state has provided
How did
no
it establish it as a matter of law using a civil burden of proof rather than a criminal burden of proof, that as a matter of law he didn't have the mens rea?
Your Honor, our position is that Mr. Jones's affirmative evidence, along with the evidence at trial that affirmatively demonstrated that he did not have the mens rea to commit enterprise corruption, makes it highly probable that he did not commit enterprise corruption. I'm sorry, Your Honor.
Didn't one of his alleged co-conspirators say that he was absolutely up to his elbows in the conspiracy to do this with motorcycles, to resell them? I mean, so isn't that sufficient to create an issue of tribal fact, that testimony at trial at the criminal proceeding?
Well, Your Honor, the Court of Appeals found that the evidence actually affirmatively demonstrated that he wasn't a part of the enterprise and that he was isolated from the enterprise. And indeed,
No, the Court of Appeals didn't make that finding. That was not the finding of the Court of Appeals. The Court of Appeals was reversing a criminal conviction. It wasn't making an ultimate determination, nor could it have in that circumstance, on the merits of the case in a civil context.
I think, Your Honor, it's open to you here to just decide that on the evidence that we have, which is the affirmative evidence that Mr. Jones has put forward, and all of the evidence at trial, that it's highly probable that Mr. Jones did not commit enterprise corruption.
Let me ask you. Go ahead.
So are you asking us to read the entire transcript of the criminal trial and make a determination as a matter of law that your client was innocent?
No, Your Honor, we've pointed to the affirmative evidence at trial that demonstrates that Mr. Jones
How can we make that decision? I mean, you didn't give us all of the evidence. You chose what you wanted to give us. How can we determine from that, given that we don't have the rest of the testimony, whether or not he's innocent?
Your Honor, the standard is whether it is highly probable that Mr. Jones did not commit enterprise corruption. And given that the state has provided no evidence that Mr. Jones's state of mind, that Mr. Jones's state of mind was different to what he is putting forward in his affidavit and in his deposition testimony, I think you can find that it is highly probable that he did not commit enterprise corruption.
I'm sorry, but don't you also have to establish that the claimant didn't, by any of his own conduct, cause or bring about his conviction? So that seems to be an even sort of a different inquiry from whether he is actually innocent of the particular charged offense.
Yes, that's correct, Your Honor. And our position is that Section 8B5D concerns conduct which might have interfered with the criminal justice process at trial. So that cannot be the same conduct that might be disqualifying under subsection 5C. And that's consistent with the purposes of the Act. In Section 8B1.
I'm sorry, if there's testimony that he committed illegal acts, that he was involved in stealing the motorcycles and selling them to an undercover officer, and there clearly was abundant testimony as to that at trial, wouldn't that by itself be enough to create an issue of fact as to whether he caused his own conviction?
No, Your Honor, because that conduct, for one, our position is that conduct is irrelevant because it was not an act charged.
But why does that might matter for the first prong about innocence or lack of innocence, but how does that affect the prong as to causing his own conviction?
Because subsection 5D should deal with conduct that interferes with the criminal justice process at trial. So that does not include the type of conduct that is alleged to be the criminal conduct for which Mr. Jones was being prosecuted.
Thank you. I have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, Andrea Trento from the Attorney General's Office for the State Respondent. I'm going to start with the enterprise corruption charge and the overturning of that conviction. As Your Honors are well aware, it's well established that the overturning of a conviction by itself does not satisfy the requirement to establish innocence. But I wanted to point the court to evidence in the record of Mr. Jones's, at least raises a question as to Mr. Jones's guilt. Mr. Dawson, the cooperating witness, testified that he considered Mr. Jones a business partner of his in connection with these transactions, and met with him over 40 times with regard to transactions like the ones at issue here. Moreover, the court heard evidence, Mr. Dawson proffered evidence that Mr. Jones was actually involved in 5 additional pattern acts that was not introduced to the jury because of the nature in which they were discovered. But the court considered those 5 additional pattern acts in sentencing Mr. Jones. And so we would submit there are ample questions in the record as to whether Mr. Jones is, in fact, by clear and convincing evidence, innocent of the crime of enterprise corruption. But enterprise corruption is not the only act charged in the accusatory instrument here. There are
Aren't the other acts, the predicate acts, really just predicates because he couldn't be charged with them as separate crimes because they occurred in a different jurisdiction. So the Manhattan DA could not charge him for the 3 predicate acts.
That's correct, Your Honor, but that doesn't change the fact that they are charged.
So that's just fortuitous, that he did the acts, but he did them in another jurisdiction, so we couldn't have charged him separately with violations on those particular predicate acts.
That's correct, Your Honor, but the pattern acts themselves, as a matter of the criminal procedure law, the pattern acts are charged acts in the accusatory instrument. The court does not need to draw lines about uncharged conduct. The court does not need to worry about a slippery slope as to what kind of conduct.
But it's also frequently the case that the pattern acts are separately charged in the accusatory instrument, right? I mean, as long as they occurred in the correct jurisdiction.
They are often separately charged as additional counts in an accusatory instrument.
Better way to put it.
But under, if I could point the court to the criminal procedure law, a statute regarding enterprise corruption, section 300.10, subdivision 6, specifically provides that in an enterprise corruption prosecution, and I quote, the court must specifically designate and separately submit for jury consideration those criminal acts which are contained and charged in the indictment. It's not referring to separate counts here. It's talking about the pattern acts that comprise the enterprise corruption charge. And so these are criminal acts the jury must separately find, the jury separately charged, that under Section 8B, a claimant must prove his innocence of in a pattern.
Well, maybe the word charge has a different meaning under the penal law, particularly as it relates to enterprise corruption on the one hand, and then the unjust conviction law on the other.
Well, I would refer the court to the statutory, the canon of statutory interpretation that related statutes that use similar terms should be interpreted consistently. And I would submit that charged, when the Court of Appeals refers to pattern acts as being charged against the defendant, when the criminal code refers to pattern acts as being charged against the defendant, and when Section 8B requires a claimant to prove his innocence as to the acts charged in the criminal indictment, charged means the same thing in those contexts.
With respect to the third element, whether or not the claimant brought about or caused his or her own conviction, is your friend right that the conduct contemplated there is conduct that frustrates the criminal trial, or does it have a broader meaning?
Respectfully, no, Your Honor. In fact, there's no court that has specifically held that that conduct is limited to, I'll refer to it sometimes as the courts do, as post-crime conduct. There are courts, however, that acknowledge that the court can consider pre-crime conduct in determining whether the claimant caused or brought about his own conviction.
Admittedly, in fairness to your friend, though, the non-exhaustive lists that the Law Revision Commission came up with seem to me to indicate all efforts to thwart the criminal trial.
Those examples do suggest that, but the courts have interpreted that. They've interpreted the statute to say that leaves the courts with broad discretion to determine what kind of conduct serves as a bar under Section 8B5D. And in this case, if the court declines to consider the pattern acts as acts charged in the accusatory instrument, then it is a perfect case, if you will, of the kind of conduct, the kind of misconduct that would subject a claimant to the bar under Section 8B5D. I think my time is out.
Your Honours, Mr. Jones did not commit the predicate acts, was not charged with the predicate acts that are detailed in the accusatory instrument, and indeed he could not be charged with those predicate acts because they occurred in different jurisdictions to New York County. And so the law is on our side here. The state has provided no persuasive authority that actually states that uncharged acts should be acts charged in the accusatory instrument for the purposes of subsection 5C. And if you follow the state's interpretation here, then you'll have to go against the Court of Claims' decision in Albright, the Second Department in Chalmers, and the Third Department in Laval-Jones.
Counsel, how do you address counsel's argument about the statements made by Mr. Dawson concerning Mr. Jones' role in this activity?
Your Honor, Mr. Dawson also made statements that affirmatively demonstrated that Mr. Jones was not part of the enterprise, that and those statements are not relevant in our opinion because those uncharged acts are not relevant.
Thank you. People versus Chacon.
May it please the court, Alma Gonzalez for Mr. Chacon. The court should reverse Mr. Chacon's conviction or remand for a 440 hearing. And before turning to the Brady claim, Your Honors, I'd like to briefly just recount the timeline of the belated disclosure that's at issue here, specifically the transfer agreement that was made with Gabriel Gonzalez, the star witness in this case. So Gabriel Gonzalez was the main identifier.
We're familiar with the case, but why don't you focus on your argument why this constitutes Brady material?
Sure, Your Honor. So
and specifically, maybe you could focus on the agreement was by the federal jail system to change one federal spot to another. So how is this anything that the state did which would constitute Brady material?
So this could be Brady material if one of two things is true. The first is if there was that direct quid pro quo, and it doesn't have to be necessarily that, that the prosecutor, the state prosecutor, was able to facilitate that transfer. It would have been sufficient if the state prosecutor, for example, would have advocated for that transfer. And the second scenario where this would be Brady material is if the witness himself believed that he had leverage with his testimony to get a benefit. And that's why the timeline is so crucial, Your Honors, because what happens is that Gabriel Gonzalez enters into an agreement with the federal prosecutor in 2017, a year before he ends up coming forward in this case. A year passes by, he still never reveals that he knows who the shooter is. And then at the last moment, just a few days before this case is about to end in trial, he comes forward and says, oh no, I actually do know who the shooter is.
Even if we assume, for purposes of argument, that something was done by the state as opposed to the federal government, what was offered to him in exchange for that? What are you alleging was offered that would make it into Brady material?
So it is this transfer, and again, I would...
Well, the transfer is what they allegedly gave him. What was it in exchange for?
For his testimony, Your Honor. So that's what he bartered. When he entered...
Counsel, I'm sorry, but didn't the jury already have before it that Mr. Gonzalez was a cooperating witness and that he had been promised something about his sentence? I mean, they already knew that he had an interest.
Yes, Your Honor, but, at that point in time, what the jury had to do really is evaluate whether he was credible or not, whether he had a motive to lie or not, and by him just coming forward and saying, oh yes, I have this separate agreement and I can't lie under this agreement and I'm avoiding 2 life terms by it, yes, that is a sufficient enough motive for him maybe to tell the truth, but what the transfer agreement does is it gives him a motive to lie, which the jury just did not get a chance to hear.
Doesn't a cooperation agreement give him... Go ahead.
Go ahead.
No, go ahead.
But I thought that he was transferred for his safety.
That's what respondent is saying was brought up during the proffer agreement. He said that people are coming to me saying that I'm a cooperator, please transfer me. But we don't know that that was actually Gonzalez's motivation, true motivation for coming forward. That's what we're questioning, because if it had really been for his safety, he could have come to the AUSA's office months beforehand saying, hey, look, I'm in danger of transferring, but he chose this specific time to come forward, and then in the instant that he's in front of the state prosecutor, that's when he asks for this transfer. So that's really the curious
Let me
thing
ask you,
here.
why would a transfer to another facility be a greater motivation to lie than a cooperation agreement where you're getting a more favorable, you know, sentence in your own case? Why wouldn't that be a much greater motivation for him to lie if he was going to lie than any transfer to another facility would be?
Because it's the only specific real benefit that he's getting in connection with this case. He had been, you know, cooperating with the federal prosecutor for an entire year beforehand, so he was well on his way to getting that benefit in the federal prosecution. And so this is the one thing that he specifically requests in the context of this case. And he could have wanted that for a number of reasons. Sometimes, you know, our clients want to be moved to another facility simply to be closer to their families. There could have been a number of reasons. But the key thing is that Gabriel Gonzalez himself believed, if I come forward with this information now, and this was really the last opportunity to do so, I can request this transfer.
Why don't you address, because we're running out of time, how this would have made any difference in this case? Because there was a very strong case here based on the tattoos, 2 identifications. What difference would this have made ultimately in terms of affecting the verdict?
Yeah, I do.
Because even if his testimony was discarded, isn't there a separate, much stronger identification from Perez?
There wasn't. In fact, Gonzalez was brought in and allowed to testify because he had the stronger basis for identification, because he claimed to actually know Mr. Chacon before the shooting. And the trial court says that. You know, the trial court says there really is no basis for the jury to identify Mr. Chacon as a shooter in the video, because the video is very bad quality. So you can't simply just look at the pictures and look at the video and identify Mr. Chacon as a shooter. And so the reason why Gonzalez is brought in is because Henry Perez, who was the second identification witness, had no prior knowledge of the shooter or of Mr. Chacon.
He'd hung out with the shooter for 4 or 5 hours, though, right?
Go ahead.
No.
I was going to say you could ask on rebuttal.
We'll save it for rebuttal.
Okay.
No, it's okay, I just want to.
May it please the court, Matthew White for the people. Shirtless. Defendant was shirtless when he murdered Barami Garcia on video, and so the jury could see the tattoos on his body and compare
I
them.
watched the video, counsel. You could sort of see the Appellate tattoos on his forearms, but it was very hard to see anything else.
There's 4 very distinctive patches of tattoos, I submit, Your Honor. I could show them to you briefly, if I may.
Yeah, that's the still picture. I'm talking about you were talking about the video. I'm just saying what the video could show.
Right, but the video shows the tattoos in the same place, the same shape, the same size, the same color. And then here is the video of the picture of the front, People's Exhibit 2. You can see there, and on the chest. So it's 4 different patches of tattoos that the jury could look at and compare with what's on the video. And that's in fact what they did. That was the very first jury note. Show us the videos and show us the tattoos. And then there was the other evidence. There was the 2 eyewitnesses who identified defendant.
Well, plaintiff describes the Gonzalez ID as the linchpin of the case. Do you agree with that?
No, Your Honor. We were going to try the case without Gonzalez. He wasn't mentioned in opening statements. He wasn't on our witness list. We didn't know of him until mid-trial on Wednesday, October 25th, I believe. The feds notified us, said we had a witness who may have information for you. The prosecutor asked for a continuance, interviewed him on that Thursday. And that Thursday was when he was shown the video of the shooting and identified the defendant. But the Brady claim rests on a misunderstanding that Gonzalez only came forward at trial. In fact, a year before the trial, during the proffer agreement, Gonzalez told the federal authorities that he was there the day of the shooting and that defendant was there, but that he left before the shooting, but had heard about it later. And that was exactly what his testimony was at trial, with the addition of having viewed the video and having known defendant for a year, he could ID him as a layperson identification. Gonzalez testified pursuant to a federal cooperation agreement that was all stick, no carrot in the vernacular. He was forced to testify by the feds. The people of the state of New York had no ability to promise Gonzalez anything, and the trial prosecutor, denied making any promises for his testimony.
Did you
Gonzalez was,
specifically address the transfer?
he was transferred for his own safety. He was being confronted on rumors of cooperation in jail, and the possibility of his relocation was in the cooperation agreement, which was disclosed to defense counsel.
That may very well be true, but that didn't come out at a hearing, did it? For the reason for his purported transfer?
It was in the motion papers, Your Honor. Everything was in the motion
It
papers.
certainly is not unheard of that a defendant might want to, particularly if they have family downstate, want to be, closer to home, so to speak, for visits or whatnot. So there may be some quote-unquote benefit to the facility in which the inmate's going to be housed.
That's very speculative, especially because, sorry, I just want to get my notes. The notes were taken by a prosecutor, and the notes say being confronted on rumors of cooperating, right? So, and that's sort of the way defense counsel opened her arguments. Well, it could have been Brady if this, it could have been Brady if that, but it's all speculative. There's no evidentiary
Difficult
basis.
for what else can the defendant do in those circumstances but speculate? They're not privy to the information. That's why they ask for a hearing.
That's why they ask for a hearing, but they have to be entitled to one. They have to overcome the evidentiary, they have to provide an evidentiary basis that they're entitled to one, and we provided an explanation for what happened that's uncontroverted. And, and that's the funny thing in a way about this case, is Gonzalez's testimony was duplicative of Henry Perez's testimony. So, as Your Honor pointed out, even if you excluded Gonzalez, we didn't know about him, we were going to proceed without him, he still would have been found guilty. That's ultimately why none of this makes any difference to the case. And unless Your Honors have any questions, I ask that you affirm.
Did the alleged alteration of the defendant's tattoos come out at trial?
I'm sorry?
There was some allegation in your papers that he changed his tattoos while he was at Rikers waiting for trial. Did some alteration to his tattoo?
That did not come out at trial.
Okay.
Thank you.
Thank you.
The video simply was not enough to identify Mr. Chacon as the shooter in the video. Respondent states that very clearly at several points in their brief. The trial court found that that's why, again, Gonzalez was brought in. And the court said, if there is somebody who knows Mr. Chacon better, the video being of the quality that it is, I think that kind of testimony would be appropriate if there's a proper foundation for it. That's why Gonzalez is so important and why he is the linchpin of this case. And this would have been a much different case had Gonzalez not testified, because if this case just hinged on the testimony of Henry Perez, who did not know either the shooter or Mr. Chacon and had been drinking for several hours that night, it's very doubtful that the jury would have convicted here. Gonzalez really changed everything. And this court found in Flores back in May, the Court of Appeals found in Hunter back in 2008 that where there's a case where it hinges on the credibility of a witness, anything that
Flores was really just about the credibility of the various witnesses. There was really nothing else. Here you have the video, you have Mr. Kendry Perez's testimony. I mean, there was other things to work with.
It still rested just on that identification testimony, Your Honor, because the video was not enough. And the prosecution in summation says that the witnesses coming forward are able to show the jury and help the jury see what the video cannot show, and that's who the actual shooter was. And so, if there was any possibility that Gonzalez had any motive to lie, whether it was a transfer agreement or any other reason, that could have been the difference. And just to end on this, Your Honors, there is also a newly discovered evidence claim. After the trial, it comes out that Gonzalez had, in fact, given inaccurate information in the past and shifting accounts of his accounts.
Thank you. We're familiar with the record.
Thank you, Your Honors.
Thank you. Hemingway Group versus I-80 Group.
Good afternoon, Your Honors. Tom Colley on behalf of the defendants. In defendant's appeal, Your Honor, the issue is whether a contract's complete absence of discussing a topic, complete silence on a topic that could have been discussed by the parties, could have been addressed, creates ambiguity in the contract. And our position is under New York law and Delaware law, which apply, two of the contracts are New York, two are Delaware, that if a contract says nothing, it's completely silent on a topic, that does not create ambiguity. In order for you to have ambiguity in a contract, you have to be able to point to something in the contract that
Let
says...
me ask you,
Sure.
isn't there a distinction between the two different entities in terms of the revenues and what entitlement there is to funds? And I'll refer to as GP and I-80 Group for
Right,
purposes
the
of
management
argument.
company and the
So
GP.
they're different, they have different revenue streams. But just by looking at the unambiguous terms of the agreement, the I-80 Group agreement refers to management fees that are generated by the company, where the GP agreement specifically limits proceeds to income derived from the fund. So shouldn't those two agreements be treated differently for purposes of our analysis, just based on their provisions themselves?
Sure, Your Honor. So the way hedge funds are set up, there's a management company and there's a GP. The management company gets a management fee. The GP gets a percentage of the profits that is made by the underlying fund. That's why most...
So my question then is, with respect to the management company, where does it provide in the agreement that the amount of revenue that the partners are limited to, or the members are limited to, is just the management fees for that company versus all companies that it provides?
Well, because that's where it's silent, Your Honor. The management agreement talks about the fund. It mentions the
Doesn't
fund.
limit it anyway, as opposed to the fund, which does, the GP, which does limit it to the fund.
Right, but...
So why should we, as a matter of law, say that it is limited to just...
Because the management agreement only refers to the fund. It talks about this, we've quoted in our brief, where it talks about the profitability of the management company will relate to its ability to manage the fund.
But where does it unambiguous, we're talking about unambiguous, and I see the argument you're making about the unambiguous language with respect to the GP agreement, which does limit it to the fund, but I don't see the equivalent language with respect to the I-80 Group agreement.
Well,
so what's the language there that specifically limits it?
Because it defines the fund in the agreement. It only refers to the fund. It never talks about any other fund. And that's where it's silent. And that's what
So you're saying the silence should be construed in your favor as a matter of law?
No, I'm saying...
Because it's one thing, there's an argument to be made with the GP that there's specific language you're relying on.
Correct.
The other thing, you're just relying on silence. So silence could mean either way.
Well, it's not...
Why, as a matter of law, should we say it's your way?
Well, it's not silent in the sense that it does refer to an entity from which management fees will be derived, and that is the fund. It only refers to the fund, it defines it, and uses a capital F to refer to it as the fund. It says nothing about other funds, and that's the silence. And to say that that creates ambiguity because it says nothing about other investment opportunities that Mr. Hawani may have.
There's nothing, what in it limits it, though? I guess, what is the language in there that actually limits it to just investment services for that fund as opposed to any investment services it provides?
Right, but
as an entity.
And the other entities, they're named I-80, but they could be named anything else. There's no reference to any other business opportunities that Mr. Hawani may have outside of the fund. There's only one entity mentioned in the management agreement, one entity mentioned in a GP agreement, and that is the capital F fund. It says nothing about the other. And the issue here is, does that create ambiguity? Because it says nothing about those other entities. And I submit that that does not create ambiguity. To create ambiguity in a contract, you've got to say, here's a provision of the contract that's not clear what it means. They can point to no provisions unclear.
If the contract doesn't address something and is silent on something, it's not ambiguity, but it doesn't address what the answer is necessarily.
Well, our position is silence isn't the basis for ambiguity. Silence is, when it's something that they could have discussed or considered, silence does not create ambiguity. And that's
Let me ask you, because the language, I'm looking at the language. It's defined as, quote, all of the income of any nature received by company in connection with its providing investment management or investment advisory services. So that's very broad language. Why isn't that language sufficient to encompass any investment management or investment advisory services provided by a Group?
So all of the investment management services that were provided revenue from the fund. It came from the fund. All those management fees did go to the I-80 management company. What we're talking about here is a different set of companies, a different management company, a different GP, and a different fund. They got all, and the all relates to the fund. The only management fees that ever went to the I-80 manager was from the
They're
fund.
alleging that the Iconic deal came in through this company and that it was diverted. That's their whole argument.
No, it came in through defendant Hawani, who set up other companies. And those other companies could have been called something else. They could have been called ABC companies. And there's nothing that talked about ABC companies here. Some of the confusion
Why'd
relates
they
to...
ask them to change their interest? Why'd they ask them to go out of their membership and go into another membership?
Because he started this with his friends and family. And he offered his friends and family, if I do happen to set anything up, I will give you an opportunity to participate. He offered them that. There's no contract that says that. The plaintiff's argument is, well, we have a specific 2.25% we're entitled to. They're not entitled to that. There's no contract.
You'll have time to rebuttal. Thank you.
Good afternoon, Your Honors. Michael Hannon from Caswood Benson on behalf of the plaintiffs, appellants, and respondents, Hemingway Group. Your Honor hit the nail on the head. The appellants here seized on ambiguity in the documents in a bad faith attempt to end run the original bargain with this amendment that was a restructuring by falsely claiming that these were accounting changes that were better for Class B members when in fact they were flagrant attempts to retrade the party's initial bargain. When my client balked at that, Mr. Helwani kicked him out of the firm based on empty claims that he was defaming I-80, and the Supreme Court made an easy call and said these pled facts for breach of express and implied contract. This appeal is premised on a provably false mantra that the contracts were silent as to the nature
Let me ask you something.
of the revenue share.
The same question, actually.
Sure.
Shouldn't a distinction be made between the two entities in terms of what each agreement says with I-80 Group versus the GP, in terms of what your client might or might not have been entitled to? Because doesn't the GP unambiguously provide that it's limited to proceeds to income derived from the fund?
Your Honor, that's an issue. It's a thought.
Why shouldn't they get summary judgment on that issue?
Well, it's because you have to read all the contracts together. And the flip side of that is we could get summary judgment on the management company agreement, which is unambiguous in our favor. In fact, in that issue, this, as Your Honor was inferring, all means all, right? It's unambiguous. It's dispositive in our favor. It's a pro rata share of all management fees.
Well, why isn't... Yeah. Okay, I don't think you even moved for summary judgment on that, but the fund language is pretty specific. It limits proceeds to income derived from the fund. So that's an argument for them why they should get summary judgment. The other language is a little more unclear. I think, why can't both sides make argument with respect to that language, whether or not it should or should not be limited to management or investment services as to that company or all companies?
Well, these are several contracts that need to be read together. They're a suite of contracts. There was a purchase agreement, and then there were two LLC agreements. They constitute one agreement for purposes of New York law, and they have to be read together, and there's certainly ambiguity overall. I do think summary judgment would be appropriate in plaintiff's favor on the management agreement. There's a case we cite in our paper, Evans, and it cites as an illustration the Greenfield case, and it actually...
You didn't appeal that, did you?
No, we didn't.
No appeal from you seeking summary judgment. I'm a little confused. I mean, you did make an appeal, but you made the appeal as to another claim, not as to the...
I guess what I'm suggesting, to Your Honor's point, is that it's the defendants who are attempting to infer a limitation in the contract language in which violates the cases. Like that's what the real silence is here. There's this broad pronouncement of all fees. They're trying to limit it based on silence. And the Evans case and the cases it cites says when you have a broad pronouncement like that, it's unambiguous in favor of the party citing the broad language. That's all I'm saying. But let me address Your Honor's point about the GP agreement. There's a reason that the defendants in this case attached 12 pieces of documentary evidence to their motion to dismiss based on documentary evidence, because overall there is ambiguity, and that's why what my clients and other Class B members did is they asked the defendants to confirm, consistent with their ability to request clarification, that the revenue share in that other agreement, the general partner agreement, apply to any fund managed by I-80, not just the first one, because of the language Your Honor is referring to. And here's a sample of what we knew when we filed the complaint and we allege in the complaint. This is what Mr. Hawani told the Class B members. As a general partner, you participate in all funds we launch, independent of names. He told them, forevermore, whatever GP...
Okay, but you're now talking about extrinsic evidence, but where's the ambiguity with respect to
we're in the world... First of all, because we had the right...
Before you can come to extrinsic evidence, you have to... What is the ambiguity in the fund line?
There's the documentary...
asking,
Sure,
tell me
the
what
documentary
ambiguity-
evidence overall...
Which can't be used to create an ambiguity.
I'm
right?
sorry?
Documentary evidence can't be used to create an ambiguity. The ambiguity has to be present from the face
It's
of
the defendants who injected that documentary evidence into the case. They're the ones who relied on documentary
Well, first
evidence.
we look at the agreement. The agreement is the starting point, and if the agreement language is unambiguous, we don't get to any extrinsic evidence. So what is, with respect to the fund, as opposed to the management services, what is the language that is ambiguous in the agreement itself, as to it being limited to the fund?
In that particular agreement, it does not say what happens if Mr. Hawani attempts to raise money through a different fund. But that particular interpretation doesn't make any sense. It can't be that the defendants could at any moment create a brand new fund to do business or create a brand new investment manager to manage the funds to render our agreement worthless. And so there is an inherent commercial unreasonableness in the idea that the revenue share, even in that GP agreement, was limited to one fund. That could not be the case. It couldn't be that on day 2 of this agreement, Mr. Hawani could say, you know what, I'm not going to raise money for this general partner through my first fund. I'm going to start raising money through a brand new fund, and you know what, original investors, you get nothing.
So that really goes to your breach of the implied covenant of good faith.
It certainly goes to the breach of the implied covenant. I think it's more than sufficient, given the business context of these deals and all the facts we allege, to create enough ambiguity that the court doesn't need to deliberately ignore what we have in the record, which is the defendant saying again and again in writing, they don't believe what they're arguing. That entire defense, they're saying, just don't look at what we told you on the record in writing. Because, sorry, it's unambiguous.
You're going to have time for rebuttal. Sure. No one's addressed, you didn't even address your appeal, though, so I guess you'll do that on rebuttal.
Thank you.
So I'd like to address, Your Honor, the difference between the management agreement and the GP agreement. The management agreement does define a fund. It only refers to one fund. It does refer to all revenues that are derived from management services provided. But there's only reference to one fund. What we're talking about here is a different fund that had a different management company, that had a different GP. They happen to have the same name, I-80. They could have had any other name. The plaintiff got all the revenues related to the fund through the management company. So to the extent that the management agreement talks about all revenues, they got all those from the fund. It wasn't as though they were cut out of revenues. They got 6 or 7%. Their brief talks about that. They got their principal back when they were terminated, and they got 6 or 7%. What they're saying is, when they sign that agreement, any business opportunity Mr. Hawani has in the future has to go through the fund. Well, the agreement doesn't say that, and it's silent on that. And he went up and set up another fund, another management company. He invited, these were friends and family, he invited them to come along, but he said, you don't have a contract with me for that. I'll give you a portion of that, but they wanted 2.25%. But there's nothing in the management agreement that is ambiguous. It only refers to all revenues, but it only mentions one fund.
Viewing the evidence in a light most favorable to your friend, is there a tribal issue of fact as to whether in the course of setting up these separate funds, they deprived them of the benefit of the bargain they thought they were getting?
Well, but there has to be ambiguity in the contract, right? And even if you use the implied covenant of good faith and fair dealings, what the courts look to is they say, is there something that the parties couldn't have anticipated that fairness requires us to apply this document? This is something they could have anticipated, whether he's going to go up and set up new business opportunities. They could have put that in the agreement, and they didn't. And the argument that because it's not there, they have a right to it is contrary to New York law and Delaware law. It's silent on that. The way you have to look at ambiguity...
Thank you. Thank you.
Thank you.
What's your response to that the agreement doesn't give your clients the right through all time to get any business opportunity that comes along to him, that it was for that particular fund, and he has the right to go create another fund, and You don't necessarily get a right to share in that.
And rip off his investors on the next day. That's exactly what the agreement says. Certainly with respect to the management agreement, which my friend pointed out that there's a definition of the word fund in the management agreement. What is dispositive is that under settled principles of construction, the fact that the fund was defined in that agreement, but actually not used in the provisions that talk about sharing revenue, that has to be construed as a deliberate decision not to limit Hemingway's revenue share to any particular fund. As to the other issue of a GP, friends and family, when these people got together, the idea was initially, it'll be one fund. There was no contemplation of future funds, and so the parties never thought about it.
So that's not addressed in the agreement.
It's not addressed explicitly.
There's nothing in the agreement that prevents him from going out and starting another fund.
With respect to the GP agreement, it is very much, there are several arguments on the GP agreement. One is you have to read them all together. There's sufficient ambiguity overall, and you can look at the defendant's statements that completely contradict what the defendants are saying here. The other is the implied covenant. Absolutely.
I don't know what ambiguity overall means. It seems to me ambiguity has to arise from a particular clause or paragraph. Where does that arise from?
I'm suggesting that when you read all three of the agreements together, there's sufficient ambiguity about what would happen with respect to future funds overall, and you can apply that to the general partnership agreement. But I think the implied covenant fits better when it comes to this GP agreement, given the idea that when they got together, it was only one fund. The New York law, and it's cited in our papers, you have to look at if the parties didn't contemplate something at the time of contracting, what would they have agreed to had they had the opportunity?
Thank you.
Thank you.
Schneiderman versus Brand.
Good afternoon, Your Honors. My name is Stephen Kessler. I represent Mr. and Mrs. Brand in this matter. The forfeiture settlement is unlawful and must be vacated.
Counsel, before we even get to the merits,
Yes, Your Honor.
let's address the procedural posture of this case.
Please.
Because this is a case that had been discontinued long ago. Don't you have to make some kind of motion or bring a new proceeding for this to be decided?
So we did make a motion, Your Honor, and this is the motion.
So that you can't just make a motion, you have to bring a proceeding.
That would be correct if this wasn't a matter relating to the enforcement and interpretation of the agreement, Your Honor.
Right,
So-
but the action's done, so wouldn't you have to bring a new proceeding?
The action is not done.
Isn't it discontinued?
The enforcement of the settlement is ongoing. In fact, the thing that created the issue for the AG's office is that Mr. Brand is still under the provisions of the settlement. The Attorney General's office is still under the provisions of the
Let me
settlement.
ask you another question. Let's say we even assume that that's correct, that you bring it in this way, which, for purposes of argument, this is now a direct claim against the state. Doesn't this have to be heard by the Court of Claims rather than?
Does
being heard
not.
in this
So there are two, and this was one of the issues that the lower court didn't seem to clear on. There are two matters. First, and what we've been seeking was the vacature of the forfeiture agreement because it's unlawful. The second piece had to do with additional damages against the state. It's our argument, and we believe that state sovereign immunity may be waived, but putting that aside, there is nobody who disputes the fact that the court below had jurisdiction as far as the adjudicating and enforcing the settlement itself.
But
So-
you're not just seeking to enforce the settlement, you're seeking damages. So if you're seeking damages, isn't that a claim against the state, separate and apart from enforcement of the agreement?
So if it were for the damages itself, Your Honor, then again, we believe that it may be waived, but
What may be waived?
on the appeal, we are
I'm
not
sorry, what is waived? That the state waived
sovereign
its-
immunity.
How did
And
the
the
state
cases
waive
that
its
we cite
sovereign-
in our
How did
papers.
the state waive its sovereign immunity?
By being part of the settlement in which it indicates, in which they drafted, which it indicates that the state, that the lower court has jurisdiction to enforce and interpret
That
the
settlement
agreement.
didn't say anything about the state being liable for damages. It was a settlement in which your client was liable to pay damages. The state did not take on any affirmative obligation to pay any damages in that action. It was only seeking relief against your client. So how does it bringing an action to seek relief against your client constitute a waiver of its sovereign immunity, a waiver of any right to have any case against it be heard in the Court of Claims?
So the appeal itself, Your Honor, focuses on the second piece that was seeking below, and that dealt with the vacature of the
You're seeking
settlement.
damages in this case?
No,
You're
we're not
any
seeking.
damages?
No, Your Honor. Only the damages of vacating the settlement agreement. There's no financial compensation, which I believe Your Honor was dealing with, which had to do with the first issue that was against the state. This deals with the vacating of the agreement itself because it was unlawful. So if the court were to find that there's no jurisdiction as far as the additional damages are concerned, but there was, as even the lower court implicitly recognized that there was jurisdiction because the judge went on as far as the the merits of what our argument was, then that would mandate the vacature of the settlement itself.
Thank you.
Thank you.
Time rebuttal.
May it please the court, Daniel Magee from the Attorney General's Office on behalf of respondents. I'd like to start with the procedural issues that Your Honors were just asking about, which do independently require affirmance here. And I'd like to stress a key point, which is that my friend here did not challenge these bases for the dismissal of his motion in his appellate brief. And he's therefore forfeited those arguments on appeal. These were the first two reasons for the dismissal of the motion was that there's no such thing as a motion for damages, particularly in a closed case like this one, and also there's no subject matter jurisdiction. Neither of those bases were challenged. Moving on from forfeiture, though, the bases were correct. There's no such thing. You cannot file a motion for damages. You cannot seek damages against the state in Supreme Court. The action had to be filed in the Court of Claims. And to the extent they were filing a motion to vacate the settlement, there's also clear case law from the Court of Appeals and this court that once a case is closed and the claims have been dismissed, you have to file a new action to vacate a settlement. You cannot file a motion in a closed case. So all of those procedural reasons, subject matter jurisdiction, and the deficiencies in the motion by themselves warrant affirmance
We should
here.
not get to the merits in this case.
You don't need to reach the merits in this case, but if you would like to, the merits also support affirmance here. There's no reason to unwind the settlement. The settlement was negotiated with counsel. This counsel here negotiated the civil settlement as part of a global resolution of a criminal and civil case against Alan Brand. He pled guilty, agreed to plead guilty to enterprise corruption as well as other felonies that could have resulted in serious jail time. But he only got probation because he agreed to plead guilty and to pay a forfeiture. He's now seeking to essentially 5 years later say, well, I should get all the benefits of pleading guilty, getting no jail time, but none of the burdens. I shouldn't have to pay any of the money because 5 years later, I realized or would like to make these arguments that there was no basis to enter the settlement in the first place. Putting even that aside, all of the arguments are also meritless. This settlement does relate to criminal conduct. He pled guilty to the crimes that are the basis of the settlement agreement. That guilty plea's never been vacated. He never moved to withdraw that guilty plea. The case law is clear that if you plead guilty to a crime, you cannot challenge the basis for your guilty plea in a civil proceeding. So he's stopped from making any of these arguments. The second argument, I believe, is that this doesn't relate to Medicaid fraud. The complaint is clear that this relates to Medicaid fraud. There was false reimbursement claims made. There were no-show jobs, kickbacks. All of that relates to Medicaid to the extent there is part of...
We shouldn't get to any of this because he didn't even raise it.
You don't need
in
to
his
get to
moving
any of
case.
this. And I take it from that question that I can stop here and rest on the procedural arguments. The merits arguments are raised in our brief.
Why don't we hear back from him on that?
Thank you, Your Honors.
Thank you.
The egregious nature of this case, Your Honor, is shown by one thing. A detective with the NYPD for 25 years and the investigator with the
Counsel,
AG's
before-
office for
before we get
24
to that,
years.
Why didn't you raise any of this in your, the two
Well, we
primary...
did raise jurisdiction,
The
Your
two primary
Honor.
issues the court dismissed on below were not raised in your moving papers.
That's not true. It's, and...
Not true?
And no, it's not. And the AG saying it's true doesn't make it so.
Well, reviewing the
You
brief
raised it in your
makes
reply,
so.
but in your initial brief, you want to give us some page numbers?
I don't have it in front of me,
I
Your
didn't
Honor.
see it.
But we do, well, I know in the fact section we talked about it. It was not one of the points that was raised. We did appeal each and every part of the lower court's
And
decision.
counsel, in your motion, you did seek money from the state, right? $2 million? Didn't you seek $2 million?
I don't believe that's the figure, Your Honor. I don't remember how much it was below. But
I mean, something would flow.
spent
If you were able to
30+
rescind
pages.
the settlement agreement, then you're saying we should be able to claw back money, right?
We spent 30+ pages on our brief below, not before this court, on vacating the unlawful judgment.
Right, but in your brief, one heading is the brands are entitled to damages for breach
That
of
is
the
correct,
settlement.
Your Honor.
So, but
And-
you've been telling us that you weren't seeking damages. I don't
No,
understand.
I did
Excuse
not.
me.
And if I said that, I misspoke.
Well,
What
you
I
did
said
say
was
that
if the
at
court
least
is
twice.
inclined to say there is no jurisdiction on the damages, there is still jurisdiction that the lower court acknowledged as far as the settlement itself is
Thank you.
concerned.
Thank you very much. People versus Johnson.
Thank you.
What?
Good afternoon. Simon Greenberg on behalf of Larry Johnson. The dispositive issue in this SORA appeal is whether the prosecution presented clear and convincing evidence that Mr. Johnson used forcible compulsion. And if the prosecution did not meet that burden of proof, the court must subtract 10 points, resulting in a total RAI score of 70 and a presumptive level 1.
Counsel, why couldn't the court credit the 12-year-old victim's initial account? I know that she told different...
Which account, Your Honor, are you
the initial
referring to?
account was that she was raped.
The initial account made to whom?
Well, it's in the pre-sentence, I mean, in the, whatever they call it for...
The hospital.
Yeah, at the hospital statement. She said it to... Yeah.
I'm sorry. The hospital, according to the case summary, the pre-sentence report, and the Brady disclosure, that she did not make a sexual disclosure that there was any sexual conduct to hospital staff. It says that at the hospital she did not make a sexual disclosure, and when she
I'm sorry, she recanted at the hospital. She made it
we
before the
don't-
hospital.
well, there's no specific evidence of the statement that this initial account. I'm not aware of a specific statement that is attributed to the complainant.
It's in the case summaries in the PSI that was the initial statement that she made.
Well, the case summary and the pre-sentence report say that she.
Defendant pushed the victim to the ground, pulled down her pants, punched her in the face when she struggled with him.
Right. Yeah.
Both
Yes.
say that.
There is a statement that she made that statement. I don't believe that that is the initial statement that she made. I think that's the statement she made to the district attorney's office when after my client was arrested.
Why isn't that enough? Why what I just read, why isn't that enough?
It's not enough because of the 2 days after, within 2 days after my client was charged here, the district attorney's office made 2 Brady disclosures containing total 4 statements that contradicted the account in the case summary and the pre-sentence report. No 2 of the complainant's statements here were consistent with each other. She never made a sworn statement accusing Mr. Johnson of forcible compulsion. Yes, Your Honor?
20 years ago, people thought it was really important if rape victims said different things, and they thought that was entirely dispositive, that they were lying and that the defendant had done nothing wrong. we've advanced a lot in our understanding of these issues since then, and we understand that rape victims, especially a child, is likely to say different things at different times because of the terror of what was done to her. And you seem to be disregarding that. The question is why it wasn't appropriate for the Board of Examiners to decide that her affirmative statement wasn't accurate and to rely on that. And so I
Yes, Your Honor.
haven't
Well, the
heard
board
a good
is not.
answer to that.
I don't believe the board is charged with making a credibility or a reliability determination here, and there was no sworn statement at any time. And the district attorney's office offered a plea agreement where my client did not have to admit that he used forcible compulsion. The complainant never testified in the grand jury proceeding. There's just
He was convicted. Are you saying that they can't rely on that at all?
he was convicted of second-degree rape and was not required or asked to admit to using forcible compulsion. He did rape her. He had sex with someone who was not old enough to consent to sexual conduct. That's a crime. Forcible compulsion is not an element of that crime, and the only evidence here of forcible compulsion is contradicted by a series of irreconcilable, inconsistent statements, every single one of which is hearsay. The accusation of forcible
Right, but
compulsion.
they're allowed to rely on hearsay. And
They are, but I don't think
nothing
that
wrong
they're
with relying on
they're
hearsay. They're
allowed
all
to.
hearsay.
I don't think they're allowed to speculate and just without any other context decide.
Usually that's all there is in these SORA cases, is it's the PSIs and the case summary. That's what's before the SORA court. That's how the SORA court has to make a determination. So if they couldn't rely on the case summary and the PSI, they'd never be able to make
They can rely on the case summary and the PSI as admissible evidence. But
I have a question for you.
Yes, Your Honor.
The PSI and the case summary, because I read to you the victim's statements. My question to you is, were there any inconsistencies in the PSI and the case summary regarding everything that the defendant did?
So
That's usually a yes or no.
Yes, Your Honor. Well,
what are the Are there any inconsistencies between the statements in the PSI and the case summary? Any inconsistent statements?
The case summary does not include every detail that's in the pre-sentence report, and also the pre-sentence report.
Well,
And
let me pose it this way, because I've read to you what defendant did. So my question is, did the PSI and case summary contradict each other regarding the versions of what happened?
The case summary and the pre-sentence report do not contradict each other, but that's because the case summary was drawn from the pre-sentence report. But what both the pre-sentence report and the case summary were missing, actually, was the complainant's statement that she made a day after she met with the district attorney's office and the detective, where she specifically said, "What I said to you yesterday when I told you that he punched me in the face and he pushed me to the ground, that wasn't what happened."
Thank you. You're going to have time for rebuttal.
Thank you, Your Honor.
May it please the court, Sharon Knight for the people.
Can
Your
you
Honor,
address specifically the reason why, despite the fact that the victim may have said different things, a conclusion can't be reached as to whether or not defendant engaged in forcible compulsion?
oh, her statements, any discrepancies in her statements do not foreclose a finding of forcible rape. She, in the beginning, and like you said perfectly, as a 12-year-old child, to be terrified of what's going on, she went to the hospital. There was a rape kit done, so there had to be some indication that something like that had happened. In the very beginning, she denied it until the DNA was a match. And then the defendant was arrested and she was brought in, and she said, "I was untruthful, and I was untruthful because I did not want police involvement." So this is all explained. And then 2 days after the defendant's arraignment, now they're acquaintances, and I think that's important to bring out and to consider. So 2 days after his arraignment, when he already sees the charges that are before him, the victim comes back and this is in a Brady disclosure by the ADA, and says, oh, there was no force. This is all like very convenient for the defendant, and the SORA court could have reasonably concluded that this defendant was pressuring this young girl, first not to say that he had raped her, then when he couldn't deny that he raped her because it was a DNA match.
But what would the basis of that finding be, that the defendant pressured the victim into changing her narrative?
Well, they were acquaintances, and in the case summary, it does say that they met on a few occasions, presumably after the rape. So this wasn't a stranger rape. I mean, they knew each other. But there's nothing in her statements. Oh, and also as far as that July 18th, that second statement that she made, which said there was no force, even though the board, well, first of all, there's no evidence the board didn't have that before it and didn't put it in the case summary. However, it's irrelevant that the board didn't consider it because the SORA court did. And the SORA court isn't bound by the board's determination. So the SORA court had this in front of it, and it's entitled, it has the, it's permitted to disregard any statements that it finds to be untruthful and credit any statements that it finds to be truthful.
But of course, how are we gauging truthfulness in this regard? Normally, we would gauge truthfulness by having a hearing or a trial, and the demeanor of the witness can be evaluated by the fact finder. Here, we're choosing between different written statements, some of which may be hearsay.
Well, hearsay is permitted. Reliable
It
hearsay
certainly is permitted, but the burden is clear and convincing evidence, and we're choosing between different written narratives, some of which are hearsay. How do we piece together here the clear and convincing evidence of the forcible compulsion?
Well, I would say I think it's, as far as there being forcible compulsion in this matter, the evidence or with the statements?
Well, the statements were part of the evidence that could form the finding of the forcible compulsion, right?
Yes, yes. I would say what makes sense, what's reasonable? What's reasonable here? Why is this 12-year-old girl? It makes sense for her to deny it in the beginning. It makes sense for her to come forward when the defendant is already found to be a match with the DNA. So all the statements were already proved to be untruthful just by that DNA match. And then just by the timing. You know, it's reasonable for the court to have concluded that the defendant may have pressured her. And for them to disregard that last statement that came out, which said a bunch of stuff that just wasn't, well, specifically said there was no force, which was very tailored to the defendant not being found guilty of the first-degree rape. So it was very convenient for her to then come back 2 days later after his arraignment and change that statement. But as far as evidence that there was forcible compulsion, the guidelines define forcible compulsion as is to compel by either the use of physical force or a threat. And the guidelines allow the board and the court to take into account discrepancies in age, size, or strength. So here, the facts here in this case provide clear and convincing evidence that this 20-year-old defendant compelled a 12-year-old victim to have sexual intercourse with him by the use of physical force. And as Your Honor stated, the facts of this case are egregious. The PSR and the board's case summary provide the defendant grabbed the young girl's arm, brought her into a bathroom.
Thank you very much.
Thank you. We ask that the court affirm, or in the alternative, grant an upward departure.
I'll try to make, well, I only have 1 minute, Your Honor, but I think that of all the things that the prosecutor is arguing in this case, the most obviously, I think, outrageous claim that they're making is that there was a reasonable basis for the judge to determine that my client pressured this complainant after he was arraigned. There is no evidence of that whatsoever.
We don't need to make a determination about that, though, one way or another, though, to decide this case, though.
I understand that, but on rebuttal, I'm responding to an
No,
argument.
I'm asking you the question. Do we need to decide that one way or another to make a determination on this case?
I think
Whether or not
that
there was
I think
sufficient
that
evidence.
if the district attorney's office is claiming that the reason she recanted her accusation of forcible compulsion is that my client pressured her after he was arrested, there should be at least an iota of evidence to support that claim, which there isn't. The fact that my client was matched with DNA proves that he had sexual intercourse with her, but it does not prove that there was forcible compulsion.
Thank
And
you.
just one, can I say one more thing? Was
No,
that,
thank you very much.
Okay,
Thank
thank you, Your Honor.
Rappaport versus Nye.
May it please the court, Stephen Richmond from Clark Hill on behalf of Plaintiff Rappaport in both his capacities. There are three things to keep in mind here. First, we have one set of heirs who took possession, custody, and control of this painting.
And they took custody and control when the grandmother, Minnie, was alive, correct?
While she had the stroke, yes.
She was alive.
She was alive.
Okay, please continue.
Well, then let me do a follow-up question about them, because to me, the primary issue that has to be decided at the outset is standing. And what standing does your client have to bring this claim? If the theft happened while she was alive, then the claim would belong to Minnie. It would not belong to Seymour. So how, as a representative of Seymour's estate, could this plaintiff have standing?
Well, this is the point. There was no deliberate disinheritance. Under the law, the estate law, you would leave it to the three children. They have their third interest. If it's a painting like this, it can get liquidated, and they have their shares. If they die, and it's still not been liquidated, then the children
But why
of the...
wouldn't this claim belong to Minnie's estate as opposed to Seymour's estate?
Yeah,
And you're not representing Minnie's estate.
No, but the question for Minnie's estate and where the court dealt with it was claiming it was only a claim of theft to return the asset to Minnie's estate. There's other claims here. There are the claims of the heirs who have a piece of it if it were stolen and is still out there and now is liquidated. Then
But how do they have a claim if they don't have standing? Which Minnie's estate that had standing, and no one from Minnie's estate ever brought a lawsuit, how can there be standing in this case?
they have standing as heirs to go to the executrix or the executor of an estate and request it. The whole point here is that there was no feasibility to it. We've cited the line of cases. There's two issues here on the standing issue, and let's break them apart. The first one is to your question as to which executor would have the claim. Minnie's executrix, which was Rosalie, would have the claim to return the stolen item. The allegations of the complaint, and remember this is on a motion to dismiss, are that she was part and parcel of this attempt to take it. So it would have been futile to go to the executrix of the estate and say, put it back.
Counsel,
There-
even if you had standing, how do you get around the statute of limitations issue?
Well, it's
All
our-
of these alleged events occurred decades ago, and there was knowledge of, and there was knowledge of all of these events very long ago. How do you get around that?
Well, there's two answers to that. One is, and we briefed it, and we rely on the Appellate case, the Johnson case, and some others to say that there was no cross-appeal, there was no negation of this by the court below, which is what happened in the Niagara case that they decided, and it's simply not before this court because the judge below, on a motion to dismiss, did not deal with it. The second answer is if we were to go to the merits, there is a question as to when the actual claim accrued. It's not just a claim based on the alleged theft when Minnie had her stroke. There was, and under New York law, the statute can be triggered by the demand and the refusal to acknowledge title, which was made as late as 2019, formally in the letter by Jay Rappaport, which is another issue in the case as to why this needs to go back for a full development of the record. This was a motion to dismiss. A whole variety of extraneous documents were put into this case. The judge herself said she considered them, but she didn't necessarily apply a motion to dismiss standard.
Thank you. You'll have time for rebuttal.
Your Honors, may it please the Court, John Cahill for the respondents of the Leiden Collection, which I use air quotes because it's not an entity, and Thomas Kaplan, who is an individual, and Ilana von Tuinen, who is also an individual. Justice Maisley was 100% correct when she issued an order saying that the plaintiff didn't have standing as the grandson of a living woman who, 2 years after this alleged theft in 1970, executed a will saying she was of sound mind and body that was witnessed. That is the basis for the claim here. The grandson doesn't have the ability to do that. The grandson's claim is, give me the painting. Give me the painting. The grandson's claim to the court in Maryland when he became the administrator of his father's estate, this is in the record at 824, is I'm getting this painting so it can get reverted, so it can revert to Minnie's estate. He doesn't have the standing to represent Minnie's estate. There are a whole other bunch of reasons, like the poem "Let Me Count the Ways" by this Justice Maisley could have dismissed this claim, but that was not sufficient and more than enough to do that. We are allowed to raise the claims below under well-established law that's quoted in our brief at 2 to 3. The Niagara case that he's distinguishing, and cases like that involve when there's multiple orders appealed from. Here, there's a single order dismissing the entirety of the case. This court is entitled to and should consider the other grounds so that the Supreme Court doesn't have to go through it all again, and didn't do that. And there are at least 5 different statute of limitations that I could count off the top of my head for which these to be disclosed. 1970 theft, 1974 there was an estate winding up, that the 3-year statute to be rejected. There was a 1987 settlement agreement that was breached, that was no statute of limitations was blown. There was a 2011 demand, also statute blown. Then there was a 2015 demand to my client that was also not brought within 3 years. There's no basis for doing this. There's a whole cavalcade of other cases, failure to join necessary parties. But the fact is, Justice Maisley correctly cited the law. It's good law. It makes sense. You can't bring a claim as the beneficiary of the state absent extraordinary circumstances. There are no extraordinary circumstances here. That was not an argument made to Justice Maisley below. And even if there were, those circumstances are not before this court. I just looked quickly. I couldn't find it. I could maybe look again. But there are the sister was replaced as the administrator. I don't know why. Again, that's why laches is also an issue here. Everyone who knows anything was dead, and many of the records are gone. But there was an administrator at the end. Then there's no basis for saying that the administrators of Minnie's estate wouldn't have brought this claim, or Minnie herself could have brought the claim, but she didn't. And this plaintiff, the grandson, doesn't have the right to do that.
Thank you.
Thank you.
Good afternoon. May it please the court, Nolan Shanahan of Colshots PC on behalf of the Landau respondents. Your Honors, I really don't have much to add to what counsel for the Leiden collection has put forth. So if the court has any questions, I'm happy to address them. But
Any questions? Questions?
thank you, Your Honor.
Thank you.
To elaborate upon the questions asked me, one set of standing, the Stallsworth case set forth that the court cited below, correct, an heir doesn't have the right absent exceptional circumstances. The amended complaint is replete with exceptional circumstances.
Did you raise that below?
I'm sorry?
Did you raise that below?
I was not trial counsel, but the case was cited, and the court did cite that language. The court said an heir does not have the right to bring a case like this absent exceptional circumstances, and cited the Stallsworth case. So it was before the court, and all the red flags and all the other issues were there in the briefing.
Was exceptional circumstances specifically argued to the lower court?
Was the statute of
Was
limitations?
exceptional circumstances specifically argued, and what the exceptional circumstances were?
Because I don't think so.
I'd have to go back through the specific transcript. You have it in the record. What I'm suggesting to you is what was argued below were the red flags and the case finding.
Thank you.
Thank you.
Bradby versus Structure Tone.
Good afternoon, Your Honors. Excuse me. I'm Balinder Ricky for Appellant Structure Tone, who's the defendant. At issue is New Jersey's rule that a general contractor is under no duty to protect an employee of an independent contractor from the very hazard created by doing the contract work. Now, there are two exceptions.
Counsel, didn't Structured Tones SSSP establish a procedure for electrical box panels? And doesn't that show some foreseeability of the possibility or the danger of electrocution? The PSSP, I forget what that, or SSSP is.
Or the site-specific
Yes.
safety plan, Your Honor?
And there's some references in that
Yes.
to the boxes. So doesn't that show some foreseeability of the possibility of harm that similar to what happened allegedly here to the plaintiff?
Yes, but there are two exceptions to the immunity rule. And one of them, which the court cited, was an opportunity to remedy it, the opportunity and the ability to remedy the hazard. Am I directing my answer to
Yes,
your
please.
honesty?
So you're saying that they may have had it in their SSSP, but they couldn't do anything about it?
Well, the last opportunity to do it was actually when Mr. Bradby was at the panel box and looking at it. He was a trained, licensed, certified, experienced electrician. He himself saw the hazard. He himself saw that the circuit that he was going to be working on was not locked and it was not tagged.
But doesn't that just go to comparative negligence? How long is it? The box had been there for a month, right, on the site? That's what the record shows?
I believe there's testimony to that effect.
Okay, so what he should have done, or not, he put some tape, I guess, on the one circuit, but maybe he should have done more? But isn't that an issue of comparative negligence?
It may be, Your Honor, but the issue that we've raised is that as a qualified, licensed electrician, certified electrician, he would be going there anyway to check to make sure that that circuit was off. He would not work on any wire without checking to see that a circuit was off. Now, he goes to this panel and he sees that it's on, it's not locked, and it's not tagged, which it should be before he can work on it. He turns it off and he puts a piece of tape on it. At the same time, though, he's testified, and this goes to the issue of the opportunity to cure or to remedy the hazard.
But the remedy was not in his hands. He wasn't in charge of the electrical box. The problem was that the electrical box didn't have a cover, and that therefore everybody on the job site had access to it. And it wasn't his responsibility to address either of those, and what he did was to address his immediate problem was so that anybody coming to the box would see that they shouldn't mess with that circuit. So I think it's not the case that the last opportunity to deal with it is when he went to the box, because obviously somebody went to the box after he did. But also the real issue is the structure of the box and the maintenance of the box, and that wasn't his responsibility, right?
The box was not his responsibility, but controlling that particular circuit was.
But he couldn't do the thing he would normally have done because the box didn't have a cover. And that wasn't his responsibility.
It's not the cover so much that's the issue, Your Honor. It's the particular circuit. That's what injured him. That's what the hazard was.
I understand that, but I mean, that circuit didn't have a cover either.
And there's testimony in the record that as an electrician, he would have had the tools to shut that and lock it with a hasp.
But that wasn't part of his job description. He wasn't supposed to mess with the box except to make it safe for himself. He wasn't supposed to change the structure of the box.
Your Honor,
that was your responsibility.
He himself testified that it's extremely dangerous to do the job without ensuring that you lock it.
Right, so who had the duty to secure that box so that workers, such as an electrician, could safely perform their work? Who had that? Who had? And I'm not necessarily one entity, but who had the duty to make sure that that box was in a reasonably safe condition?
The subcontractor had that duty. His employer had that duty. Plaintiff is saying that it was the general contractor's, my client's duty. And there's a whole issue, there's another issue as to whether my client controlled the means and method of the work, and our position is there's no testimony to support that. I mean, there are these two exceptions where this immunity rule doesn't apply.
I'm going to let you get back to that on rebuttal. I'm going to let you finish that up on rebuttal at that point.
Good afternoon, Matthew Majorana for respondent, Mr. Bradby. this is a case that needs to be resolved by a jury because there are issues. This isn't a summary judgment case. What the appellants are trying to do, what Structure Tone, the general contractor who had the control, had the authority under not only the site safety plan, its own site safety plan, to enforce, to require that its specifically designated electrical hazards in this box as what they call a high hazard. Their own witness, Mr. Forsyth, testified he was there almost every day. He walked the site. He had the power to stop anything any work that he thought was unsafe, that electric boxes had to have a cover. And if they didn't have a cover, that would be a violation and would be a hazard. He testified that at some point he would have seen this box. There's no issue that this box, at least on the record on summary judgment, maybe at trial it's a different story, but there's a question of fact. There's no issue that this box didn't have a cover. So Mr. Bradby had no opportunity to secure this other than what he did, which was to put a piece of tape. Structure Tone can't delegate its safety obligations that it kept to itself. It can't delegate its safety to Mr. Bradby. If they want
What
to
about
argue,
what about to his the plaintiff's employer, the subcontract? That was your friend's point, that the duty laid with the electrical subcontractor to secure the box.
there's zero testimony that the electrical subcontractor had anything to do with placing a cover or requiring that there be a cover. And even if there was, Your Honor, Structure Tone had the obligation that it wrote in its own safety plan to ensure that safety was enforced. So hypothetically, if there was a subcontractor who didn't put a cover on, and Structure Tone comes along and sees that there's no cover, which everybody knows there's no issue, is a hazard and needs to be corrected, Structure Tone, it kept to itself by its control and its own safety plan the obligation to tell the subcontractor, you need to do something, or do something itself. Structure Tone's presence on this site was ubiquitous, and it continued to keep that control. As the court below found, Structure Tone had the presence, it had the opportunity, it had the control. Structure Tone was in the best place to do something about this cover. There's also the issue that this panel is supposed to be in a closet with a locked door. There's no evidence that there was a locked door. The point is you have to prevent access by other people. And this issue that counsel raises about hasps, the testimony in the record is that theoretically, in the abstract, there are these devices that are hasps. There is zero evidence that there in fact were hasps on this job site. Mr. Solomon testified he never saw any on this job site, even though he knows they hypothetically exist. Mr. Forsyth testified that he had no knowledge of hasps. And Mr. Bradby averred in an affidavit that there were no hasps on this job site or available to him.
But in the ordinary course, it wouldn't have been the obligation of an individual electrician to make changes to the box by installing hasps or anything like that, correct?
Exactly, Your Honor. Exactly. Structure Tone is the one who has the obligation here. They can't put it on Mr. Bradby, who then is injured as a result. You can't blame somebody else for your own fault, which is what Structure Tone is trying to do here. So, I'm sorry, if there are no other questions.
Thank you.
Thank you.
The responsibility that counsel is suggesting fell upon Structure Tone would only fall on them if they controlled the means and method of the work that was being done on the job site. There's no evidence that they were doing that. The contract between Structure Tone and Mr. Bradby's employer basically gave the duty, the obligation, the responsibility of safety to his employer, USIS. And unless it can be established that Structure Tone controlled the means and methods, then the immunity rule still applies to them.
Wasn't this more akin to a dangerous defect on the premises in that the way the electrical box was set up was inherently dangerous, which doesn't really go to a means and method, it goes to the condition of the premises and what was present there.
You're talking about the exception, Your Honor?
I'm talking about the box was a dangerous, a lack of a cover was a dangerous condition on the premises, or could be argued was a dangerous condition on the premises, as opposed to having to do with the means and method of how he was doing his
The
work.
danger to this particular plaintiff occurred because of one particular circuit that he had the ability and the experience and the knowledge to shut off. The other thing, Your Honor, is that we're talking about structure tone, being in control because it had the safety plan.
Counsel,
We
I'm
cited
gonna
two
interrupt you.
cases.
I'm really baffled by your saying that structure tone has no responsibility, because your document, found at 1105 of the record, says it's your responsibility to develop a site-specific safety policies and procedure manual, and then to implement, direct it, and enforce it.
That's right,
So
Your
why
Honor.
is that? So now you're saying you have no responsibility for that. I don't understand how
The
that.
site-specific safety plan, and there are two cases, New Jersey cases, one of them from the Appellate Division, saying just because there's a site safety plan doesn't mean that the general contractor has assumed responsibility for implementing that safety. This is part of the
Which
contract.
case is that?
I'm sorry? Your
Which case is that?
That would be the case of Mahoney versus Union Paving. We've cited it in our brief, and there's also another case, Mavrides versus Patullo, and both of them say.
Thank you very much.
Thank you, Your Honor.
Wagner versus New York City Department of Education.
Hi, good afternoon, Your Honors. My name is Joseph Aaron, and I'm here for Appellant Jimmy Wagner. So this case relates to a FOIL request, but in particular to a request for electronic records.
My question is, when DOE came back to your client and said, can you be more specific, why wasn't he more specific? Why didn't he give them a week or a day or a month? Or why didn't he give them the name of the email addresses of the principals at the company that was contracting with DOE, who presumably would have been on some of the emails that he was searching for? So why didn't he take advantage of that opportunity to give them specific information to narrow the search?
So in this particular matter, the DOE understood exactly what my client was looking for.
I'm not asking what they understood. I'm asking, they offered him an opportunity to narrow the search terms. Why didn't he take that?
He didn't know which tenant accounts to narrow it to, but he
But he could have said he gave them a period of 15 months or something. He could have asked them to look at the emails for 1 month or 1 week, and then he would have found out whether there was something going on.
So, Your
Why
Honor,
didn't he do that?
that's a good point. And in fact, that's something that we've suggested at some point, that if the parameters could be the same from any people at the DOE to any people at Scheinman Arbitration, and Microsoft actually recommends, and it's briefed heavily and hyperlinked in our underlying petition.
The question is, why didn't you do that? We now have the record we have, so the
Right.
question is what you did before, not what you theoretically could do or what they theoretically could do. It's what your request was and how they could deal with your request. So you saying after the fact, this is something that could be done, doesn't really address the validity of the FOIL request.
I understand, Your Honor. So my client wanted emails encompassing the year time frame. Now, the burden is on the agency to show that their software can't execute a request like that, meaning this is...
Why didn't they meet their burden by showing that it timed out every time they...
Okay, so that's the heart of the case, yes.
formulated it, and based on their software, that it timed out.
So I'm going to address that, because that's literally the crux of the case. Why didn't they meet their burden? So the reason they didn't meet their burden is the statute says whenever they could do it with reasonable effort. They never asked an IT person. They had an attorney do it. What happens is the DOE said they use this software called PureView by Microsoft. It's hosted by Microsoft. Microsoft supports it. They have a front end that they could use to email and to search for emails. Now, our contention in the case is that an IT person should have been consulted, because an IT person would have been able to execute the search with minimal effort as the statute requires. Our contention is that the person who did the request, who executed it, was an attorney who didn't know how to execute it, despite the fact that Microsoft says it could be done and gives various...
Isn't there a claim they did consult with IT?
I'm sorry?
Isn't there a claim that they did consult with IT?
So there is a affidavit that they put in for the first time in the Article 78.
That they did
Yes,
consult
but not
with
during the administrative portion. During the administrative portion, and that's in the record.
Why did they need to put it then? If the issue is whether or not they made a reasonable inquiry.
Well, because they never made an effort until the Article 78. Now, even at the Article 78, they acknowledge that they didn't follow Microsoft's instructions. In other words, the question here is, can the system do it? In our petition, we showed my client, Mr. Wagner, he made the identical request with the New York City Department of Health that uses the same software.
Let me ask you about that. You got a response to that, right? Mr. Wagner got a response to the DOMH FOIL request, right?
Yes, Your Honor, with exact identical parameters.
Right, and they I think that DOE tried to do the same, or they averred that they tried to do the same kind of search, and it didn't work with them because they had a lot more mailboxes to search. But my question is slightly different. Via the FOIL response from the DOMH search, couldn't he have found people from the neutral arbitrator's office that would have helped narrow the search for DOE?
Well, no one was volunteering to help my client narrow it, certainly not Scheinman Arbitration.
No, I'm saying he has email now from DOMH, right? And so maybe, I don't know, does the record show that it had any names from people from the neutral arbitrator's office that would be helpful in narrowing down the email search for DOE?
I agree with Your Honor 100%. It would be helpful, but when this request was made, I guess that information was not available, but it doesn't take away from the issue or change DOE's burden.
Thank you. You have time on rebuttal.
Could I just say one last
No,
point
you have
about
time
the
on
mailbox?
rebuttal.
Okay. Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Philip Young here on behalf of the Department of Education. So just 3 quick points here. First, the record does contain evidence that DOE reached out to its IT personnel after the searches generated these error messages, sought their advice. As a result of that discussion, they decided the best way to resolve the issue was to ask Wagner to narrow the scope of his request, which they did on 2 different occasions. Wagner refused. Second point.
You actually submit an affidavit from someone from your tech department, Mr. Kumar, in support of your answer?
Yeah, we submitted both an affidavit from the Appeals Records Access Officer and from Naresh Kumar, Your Honor. The affidavit from Ann Macadangdang, the Records Access Appeals Officer, explained the steps that DOE took, and then Naresh Kumar explained sort of the issues that the city was having with the search, that because it had so many inboxes at the Department of Education, that this search was repeatedly timing out.
But whose fault is that?
Whose fault is it that the search is timed out?
The search using a particular type of software that it times out. You were given a specific method of communication that he was looking for information on, emails. You were given a specific domain name, and you were given a specific period of time. And what more reasonably could the petitioner have asked, or information could he have given you, given that he can't know who in the Department of Education is communicating, if anyone, with the neutral arbitrator?
Well, Your Honor, I think as 2 other justices here have noted, there's several things that could have been done. I mean, first of all, as I noted, DOE presented ways that he could narrow his request in order for these searches to actually work by narrowing the date range.
Okay, so I'm glad you mentioned that. So if he submitted a FOIL request and said, I'd like all of the emails between DOE and this particular neutral for April 1st, 2021. And then here's a second request, April 2nd, 2021. Here is a third request. Would that have been sufficient? Would that have been adequate for your purposes?
I think theoretically it could be. I think certainly, I don't know the capabilities of this software system. I assume some type of search like that could work. But the problem is that he didn't make that request. He made a much broader request. The agency tried to guide him to help him narrow his request, and he never took them up on that advice.
I'm just wondering if we're, sort of exalting form over substance in that regard. If from a temporal standpoint, he could have given a day-by-day request, and that would have been enough. Why couldn't he just do one request for the 17-month period?
I think, Your Honor, theoretically he could under FOIL, and each one I would probably have to be deemed a separate request depending on how he presented it to the agency. But again, that's not what we did. That's not what he did here. He presented a much different request, and the agency tried for a period of weeks to search for those documents, to help him out by sending him emails explaining the additional steps that he could take. He didn't take the agency up on that. I'd point the court to, matter of Aaron Law, which this court decided in 2021. Very similar issue where DOE submitted an affidavit concluding that the searches that it ran based on the requests just ran forever and then repeatedly timed out. This court held that the agency made reasonable efforts. I'd point the court also to matter of Reclaim the Records, and then Jewish Press v. the state police, where the state police offered Jewish Press ways to narrow the scope of the request. Jewish Press didn't take them up on that, and the Third Department held that affirmed on reasonably described grounds.
Thank you.
Thank you, Your Honors.
Sorry. I just have a few points, so I'll speak quickly. Initially, in terms of the reasonableness of their search, they searched 1 million email accounts. It says that multiple times in their affidavit. That year, there was 137 employees at the DOE. That's in the record. So just to show how bad the search was because it was done by a lawyer who didn't know the software, as opposed to an IT person, she served maybe 8 times the amount of email accounts that she should have served. Additionally, specifically,
You're saying there were only 137 email accounts? Or did you-
137,000 employees that were active during that time period at the Department of Education, and that's in the record. But notwithstanding, over and over, they say their search timed out because they searched 1 million. In the DOH case, in their answer, they say, oh, that one worked because they only have 100,000 employees. The DOE only has another 37,000. I'm just showing how there was no reasonable effort made for the search. Another thing is the statute specifically that was enacted in 2008 says that programming should not constitute the creation of a record in the context of FOIL. So it's talking about somebody who knows IT, not an attorney who doesn't know IT. The statute contemplates.
We have that point. We got it.
Thank you very much.
Tamar Equities versus Signature Barbershop.
Good afternoon. May it please the court. Cheryl Ginsberg from Zingman and Associates on behalf of the appellant Tamar Equities Corp. The lower court's dismissal of the action against the defendant guarantor should be reversed for 2 important reasons. First, on a broader level, the statute upon which the lower court relied, New York City Administrative Code 22-1005, is unconstitutional, as persuasively held by the District Court of Melendez.
Put that first, because usually jurisprudentially, we try to resolve an issue without getting to the constitutional issue. So I don't think that comes first, does it?
Well, I can move on to the, I thought that was the quicker issue, and I know that the
We've
court has
already issued a
remanded.
bunch of decisions that if we do have to get to the constitutional issue, we're going to remand it, because that's what we're
That's
doing in
fine,
a
so I'll
number of
move on.
cases. So the only way we would be deciding this in the merits is if we can decide it without getting to the constitution.
Okay. So I do
Otherwise,
believe,
we'd remand.
yes, I believe that we could resolve this on the non-constitutional ground too. Because the decision should be reversed and the complaint reinstated because the lower court misinterpreted that law by reading it too broadly. It terminated the guarantor's liability under the lease for a full 10-year period, and not just the 16-month period that was covered by the statute.
Why isn't the fact, the guarantee law refers to a default. Why isn't the fact that the default, which triggered all the liability, happened during the guarantee law period, dispositive as to the ability to collect future rent?
There was a default that occurred during the guarantor period, but that's not the default that the plaintiff was suing here for. There is a new default every month that rent isn't paid. Pursuant to the lease, rent comes due each month. So in June 2021, the plaintiff could not have sued the defendant for rent that came due in September 21. Let's say they had to wait until September 21 to make that claim, which is what they did. And so obviously then that default came due after the statutory period.
Have you accelerated the debt?
No, we have not. So we are suing only on a monthly basis. And actually, courts have held that any rent that there was a partial non-payment prior to COVID, and in addition, that was a continuing default during COVID, they were still allowed to collect for the rent that was due prior to COVID. In the same respect, the landlord should be able to collect for rent that was due post-June 2021.
So what do you make that the lower courts have actually obviously split on this issue? Why should we go your way versus the opposing view?
I think it's a matter of statutory construction that the lower court in this case did not follow the general rules of statutory construction, really in two respects. One, it's a case where freedom of contract in those type of cases, statutes which limit freedom of contract should be narrowly construed. Here, the court was construing the statute as broadly as possible, not just for the 16-month period that's referenced in the statute itself, but for a full 10-year term of the lease. Second, the lower court did not follow the rules of statutory interpretation because they didn't take into account the intent of the lawmakers when they wrote that statute. The legislative findings are clear that the guarantee law was meant to be only temporary relief for a 16-month period. Even the city's attorneys in the Melendez case said it was only meant to apply for 16 months.
Would you agree that the dispositive issue in this case should be, though, what the lease itself says as to what is, and I know you addressed it already, but what is or is not a default as opposed to the policy reasons behind the guarantee law? That really this case should trigger that, should be based on when the default occurred and whether the default did or did not occur during the guarantee period. Do you agree with that framework?
I do agree with that framework because I believe the default occurred after June 2021, at least the default that the landlord is suing on.
And that's how you're distinguishing Madison, which is a case that held you couldn't collect any future rent because there was an acceleration?
Correct, because here the landlord did not impose the acceleration clause. So the rent in an acceleration clause case all came due at the time that the acceleration clause was invoked. Here the landlord didn't do that, so the rent was not due pursuant to the express terms of the lease. They didn't sue on it until 2022, well after the time that the guarantee law had expired, and they weren't seeking that rent from the guarantor. You don't have further questions?
Any other questions?
Save the rest for rebuttal.
Okay.
Thank you.
Good afternoon, and may it please the court. I'm Moshe Lapin here on behalf of the respondents. I believe that we addressed the textual elements of the law.
Can you address this, actually the same question that I asked opposing counsel, which is, if it boils down to when the default occurred, because that's the language in the guarantee law, when did the default occur? What's your response to her argument that the default, because there was no acceleration clause, only happens each month as the rent becomes due, and because the defaults being pursued in this case happened after the period of the guarantee law has no effect on the recoverability?
Right, I think it's playing games with the law, because the law very.
I think it's what? I'm sorry.
I feel like it's playing games with the law, with the way the law is written, what the purpose behind it was. The law focuses on the time that the default or event causing the liability. So we can play games and say, well, you know, the actual payment obligation occurred later, but we all understand that the actual default that caused the liability occurred during the COVID period. I mean, the statutory language is very, very clear, it seems to me, on that.
Though, why should there not be a distinction between cases where there is an acceleration clause, where that argument's clearly correct because it's been accelerated, and a lease such as this, where the landlord doesn't do an acceleration at that time of the initial default, the landlord has a right to bring or not bring a later action. Why isn't that a separate default?
For two reasons. First, the law focuses on the time of default, not the time that the payment obligation is due, number one. Number two is the law is basically saying that the guarantee is either enforceable or not enforceable. So what's being proposed here is that it's enforceable with respect to certain liabilities.
Well, why is the law say, I mean, the guarantee law was meant to relieve guarantors of liability during the period of when the guarantee law was in effect. Why are you saying it's the intent for it to occur? Like, let's say it's a 30-year lease.
Mm-hmm.
Are you saying that its intent was to forever release the guarantor from any liability as opposed for the period that the guarantee law was effective?
I think it's meant to cover any liabilities that resulted
What's
from
your
a
basis for
default that occurred during the COVID period because the law states that. It's very, I don't see any other way to read the law, and to suggest otherwise would present a situation where the law wouldn't make any sense because the law says that the provision is unenforceable against that guarantor. Unenforceable is not qualified. It doesn't say, well, it's unenforceable with respect to these obligations during the COVID period, which was conceded by the plaintiff, but it becomes enforceable with respect to other liabilities. It's a blanket statement. It's either enforceable or not enforceable
Is
under the law.
default defined in the guarantee law?
It's not defined in the guarantee law.
So shouldn't we then default to the normal sort of common understanding of that word? And there are two of them, that a default can either be an accelerated default, which then represents a single default and all rights and obligations are going to flow therefrom, or as your friend pointed out, that there can be a continual monthly default provided the debt is not accelerated.
So the law says that if the default giving rise to liability occurred wholly or partially during the COVID period, it becomes unenforceable. Our position is, at the very least, you would have to concede that it's partially unenforceable, which they conceded in their complaint. In addition to that, it would present, their interpretation would present a very odd scenario where if a landlord attempted to trigger an acceleration clause on June 30th, 2021, the plaintiff would have no recourse with respect to any future rent obligations, but if he waited 12 hours and initiated that acceleration clause after midnight, somehow now they have the ability to seek rent for the rest of the term. Somehow that doesn't fit into what I imagine was the intent.
Thank you so much.
Your Honors, I'd like to quickly address the intent in terms of what would make sense for the liability. My colleague here is saying it wouldn't make sense if the landlord had decided to accelerate 1 hour before the end of the period. In the same way, if the tenant had decided, I'm going to retire and go to Florida, I don't want to pay rent anymore, he's saying he could have decided that in June 2021, and that would terminate all liability of the guarantor for the next 10 years, even if it had nothing to do with COVID. And that, I think, is a nonsensical reading of the statute.
What about his point, the textual reading, the wholly or partially? The obligation arises, the default occurs wholly or partially during the relevant window period.
So I think that if there is whole or partial liability as to the guarantor, or if it's whole or partial liability during that 16-month period, then it is barred for collection for that 16-month period, not for any period before or thereafter. I think if it had meant to read that the obligation would be fully terminated, then it would have said, had the obligation occurred wholly or partially between March 7th and 2020 and June 30th, 2021, as opposed to the default being partial at that time.
Thank you.
Thank you.
Vignali versus City of New York.
Good afternoon, Your Honors. If it may please the court, Jimmy Wagner for the appellant. The question here, is it moot? And I see Justice Gesma shaking her head, agreeing with me, is it moot? The reality is we need to look at what the very question is. Is this Article 78, was it challenging the vaccine mandate? It was not. This Article 78 was challenging the religious discrimination, the religious denial of his accommodation. Whether his
Has your client suffered any employment loss, any detriment to his employment, any loss of money, or any loss of status, or anything else as a result of his actions?
He has.
What?
Mr. Vignali suffered the indignity of a bureaucrat, unnamed, denying his religious accommodation.
Apart from indignity, has he suffered any concrete employment loss?
I would say under New York City human rights law, all he needs to do is suffer an indignity to his religious accommodation request to be an aggrieved, adverse person. However,
You're not suing under the human rights law, right?
excuse me? No, this is an Article 78 challenging the determination of the agency for arbitrary and capricious error in law. So when we look at the error in law standard, Mr. Vignali clearly was aggrieved. And I would say you may want to speak to Justice Higgett, because just recently, in Mindel Farkas' case,
You may not want to do that.
Justice Higgett was
I'm
part of
always
the
eager to
panel
do that.
that said the determination, this is in Mindel Farka, the determination that denies the religious accommodation is the actual concrete injury. So the determination itself denying Mr. Vignali his religious rights come from God above. They don't come from a bureaucrat in the executive branch. They don't come from the court. His religious rights are in our state constitution. When the employer denied those religious rights, that is the injury he suffered. The employer had no legal ability or authority to deny this man his accommodation. The accommodation, he had been working for 18 months.
But there was nothing, he was never not accommodated his employment. There was nothing that happened that he was not accommodated in any way, except for the piece of paper.
A piece of paper that questioned the sincerity of his religious beliefs.
Okay.
What if that piece of paper questioned somebody's gender? That piece of paper questioned somebody's race? That would be the same concept here. It's discrimination. You cannot tell this man he is not religious enough to be entitled to the accommodation they granted him for the last 18 months. Under New York City, the way our accommodation process first works is you have to first explore the accommodation itself. If you're granting everybody this accommodation and you granted it to this appellant, he should have been allowed to maintain it. If it's a non-issue, why not just grant him the accommodation? Why do they have to commit to say he is not religious enough? He didn't meet their unnamed, unstated criteria to be entitled to a religious accommodation. That is not permitted under the New York State Constitution, under New York State human rights law, or New York City human rights law. In fact, if you look at
Mr. Wagner, sorry to interrupt you, but he was able to continue to exercise his religious beliefs the way he saw them, right?
Except for the indignity of this piece of paper that says that he is not sincerely, his religious beliefs are not sincerely
The
held.
piece of paper couldn't stop him from exercising his religious beliefs the way he saw fit.
It did stop him. It's the indignity, the damage of receiving that. The respondents had no legal authority to question this man's sincerity of his
We're
religious.
just talking about whether he suffered any adverse consequences, and if he's still able to freely exercise his religion as he sees fit, then what are the adverse?
The adverse consequences of the insult to his religion. If I was to call anybody up here a name, if I was to say, use a racial epithet, that is the injury.
No, Mr. Wagner.
Please don't do that.
Thank you.
Good afternoon, Your Honors. May it please the court. Diana Lawless on behalf of the city and the NYPD. We believe the court correctly dismissed the petition as moot. This was a petition.
Did Mr. Vignali have any adverse economic, employment, or religious consequences that you're aware of?
No. Mr. Officer Vignali, he was never on leave without pay. His employment was never terminated. There were no consequences to employment. He remained employed by the NYPD for the duration of the vaccine requirement. And it's also important to note that this petition was filed a week after the vaccine requirement was rescinded, where nothing had happened to him during that period of time.
And also, in the brief, I believe petitioner also concedes that there was no loss of pay here.
Correct. So there's nothing. What it asks for, if you look at page 43, he asked to annul the determination denying the request for the exemption from the vaccine requirement to grant the exemption. Can't do that anymore because the requirement no longer exists. I know my adversary is talking a lot about free exercise and religious beliefs. This really, I didn't really come up in the briefing, I think, until the reply brief, but if looking at the petition, the only claim I see, everything is framed as Article 78, arbitrary and capricious, the vacature of this specific decision. If you look at pages 39 to 41, I do see a claim that's about free exercise, that the termination itself, the denial, was a violation of free exercise, but because of the processes and the procedures and because of the way it was reached, which is what the court, had evaluated in other cases that are not moot. He does say at paragraph 110 that his injury was through the threat of discipline, termination, or sanction for failure to comply with the policies. It never happened. So nothing happened. I don't think there's no case cited here that the threat itself, the threat alone, did anything. There's nothing that happened to him. And this court has said many times that the mere potential that the government can act again doesn't defeat mootness.
Okay, but you're familiar with matter of FARCA, correctly? Correct, sorry.
I
correct?
don't know that. I know that if the decision came down, I don't.
And I believe, and I'll be corrected on rebuttal if I'm wrong, I believe what was decided in that case was that the 4-month statute of limitation runs from when the determination is final that the petitioner doesn't get the religious exemption.
I'm aware of that. I haven't looked at it.
Okay.
But I am aware of that.
And so if we agree with you here that this is moot, and then down the road, the petitioner faces an adverse employment action as a result of this, is he now going to be time barred from challenging whatever that adverse determination is, pointing to FARCA saying you had to challenge the adverse finding on reasonable accommodation?
I don't think so, because what we say is that there would have to be a new mandate put into place at this point. There would have to be a new procedure, a new process, a new reasonable accommodation process, and it would be about new and differing circumstances. I think that I would find it analogous to the cases I cite in my brief, Only Properties and Encore College bookstores of this court, where even if something could be implemented in a similar or same way down the road and there would have to be a new determination made, then that just restarts everything.
So they can't come back and say, because things have changed a lot over the last 3 years. There's one protocol, then there's a new one, and now we rescind some. Someone couldn't turn around next month and say, looking again at this, we don't like the fact that these folks didn't comply, and so now we are going to impose some form of discipline based on their failure to comply with the prior mandate.
I think that we've lifted it. The Department of Health eliminated the employment consequences. I think that everything that the city has said and done is that it would have to be something new. Our position in this litigation, and I believe our position consistently, is that there would be new processes, new determinations. What was done was done. And if you read the initial order, right, it was a whole set of dates. Things happened by specific dates. It was a whole process that happened by specific dates in October of 2021, I believe. So it would definitely have to be something totally new at this point. All right. Thank you, Your Honors.
When we speak about the Department of Health order, the Department of Health order explicitly included religious accommodations. The city ignored that entire portion. They did not grant any religious accommodations. What they had was unnamed bureaucrats denying everyone's religious accommodation. If we look at...
What accommodation was he denied? How was he affected in his... An accommodation for someone's religion requires that they ask that his work schedule or whatever be modified so that as not to harm his religious practice or beliefs. But what accommodation did he request that he didn't get?
That he would not have to take the COVID-19 vaccine.
Right, but he didn't ever have to take it, right?
He only did not have to take it is because the timing of it was the Board of Health...
So he never had to take it?
He's never had... But that's not the adverse action here, Judge. The adverse action here is the insult to his religion. There's a process. When you set up for religious accommodation, there's a process. You first, under New York City human rights law, request the accommodation. Once the accommodation, this is from this court, in Phillips, in Hoskins, there's no accommodation that can't be granted in the realm of accommodations. This man was granted his accommodation for 18 months. And then, out of nowhere, that accommodation that he had been using for 18 months is no longer good.
Thank you, counsel. Our last case on the calendar, RC versus City of New York.
Good afternoon, may it please the court. Lorenzo De Silvio on behalf of the city. So however you slice it, the problem with the far-reaching and detailed injunction that plaintiffs wrote here run wide and deep.
Wait, didn't the city have a big role in this process? I thought that for months and months and months, there were drafts going back and forth between the plaintiffs and the city with input from the court. So it's not as if they wrote it, right?
They wrote this injunction, Your Honor, although Supreme Court directed that it would be the police department's plan to refine over time after we submitted our second proposal, which accommodated concerns that the court and plaintiffs had raised. Plaintiffs said the next month, you know what, we'll just rewrite it.
Okay, so let me ask you a different question. I read your brief very carefully and sort of as against the implementing order. And it seemed to me that you had really two major concerns that I could identify. One is that you thought that paragraphs 8 to 10 were unnecessary and inconsistent with the statutory mandate. So if we were to, for example, modify the implementing order by deleting paragraphs 8 through 10 and the definition section that correspond to them, would that satisfy part of your concerns?
No, Your Honor. There are
Would it
parts.
satisfy your concerns at all?
It would satisfy some of the concerns.
Okay,
There are.
So if we were to do that, in order for the rest of the implementing order to be functional, would the removal of those three paragraphs affect the functionality of the rest of the agreement?
So there are parts of the detailed injunction here that could be remedied with more easy fixes.
No, I'm asking you specifically. If we remove those three paragraphs, would that impair the functionality of the rest of the implementing order in some way?
The fundamental problems would still remain, Your Honor. So,
Okay, but would that create different problems that aren't there already?
So there are certainly thorny problems that are posed by the injunction here.
Okay, but what I'm asking you is, if we deleted paragraphs 8 to 10, would that make the implementation of the implementation order less effective, less functional, more difficult?
It still would not work, Your Honor. And if
Okay, I understand you're saying it wouldn't work, but I'm asking you as if it would make it worse.
I don't think it would fix the problems, Your Honor. That's the
Let
problem.
me ask something. Let's assume for purposes of this question that we're rejecting your argument, your primary argument, which is that it should be limited to investigatory versus non-investigatory, and we don't find that to be a valid distinction. So let's put that aside, and putting that aside, wanting to create a plan that is workable. If we took out the provisions that she was just referring to, what inherently about it violates the ceiling statute and makes the plan unworkable, putting aside your issue about the investigatory versus non-investigatory?
So it's not just the statutes, it's longstanding principles of injunctive relief. Here, far from being clear, the injunction is confusing.
Let's just say, though, that the path has been set in this case to some degree because of the city's participation in this process and the city's deep involvement in this process. Both sides have basically agreed to a process where a plan is going to be hashed out by the court that is workable and that complies with the statute. Assuming that that is true, and we delete the provisions that clearly seem to be violative of the ceiling statute, what else is unworkable about the plan on a practical basis that makes it not approvable by this court?
The problem is that we never should have gotten here when plaintiffs ask for a prohibition.
You're going to investigatory, and let's say...
That's right. That's how the case was litigated.
Let's assume that we are rejecting that argument for purposes of our discussion. I'm trying to find out, because you spent a lot of your brief talking about that, so if we reject that, what else is left other than the provisions that my colleague brought up that you find objectionable? What are the concrete objections other than the fact that it goes beyond investigatory?
The guiding principles are unduly vague. They don't provide an intelligible basis from which a reasonable person could say what the injunction commands the department to do or not do. That's one basis.
So how would that be remedied?
That should also be excised. Those were things that plaintiffs added in October of 2021. I see that my time is up. I'll return on rebuttal, Your Honors. Unless you have another question.
Go ahead. You should all ask as many questions as you
Okay.
want.
I mean, it seems to me here, the problem is that you've got CPL 160.50 and 55, but then you have a matrix of other regulations and local that are pursuant to consent decrees where you have to provide information in the aggregate to different authorities. And so that's the point of the de-identified portions, the portions that Judge Gesmer asked, could we excise those and solve the problem? The whole point, I guess, that the judge went there and talked about de-identified documents is because the NYPD has a lot of obligations to provide data to other entities, right?
That's right.
And so does that have to be part of the conversation? Because the court has before it the long time noncompliance by the NYPD with CPL sections, and now it has, you have all this other data that you have to provide to entities that overlaps with what would be sealed records under those CPL sections. So does that have to be part of the conversation? All these other, the Valone report, the annual use of force report, the MTA crime report, on and on and on. Does that have to be part of the conversation in crafting relief in this case?
Your Honor, I have 3 responses to your question. I know that my time is up, but to answer it, I do want to make 3 points. One is that certainly there are competing obligations, but they all come from inferior sources of law, and plaintiffs have never identified beyond empty gestures to harmonization why the kind of policy-making judgments one would expect a legislative body to make in the first instance should be made by the judge in this case. So I know that the Supreme Court has lived with this case for a long time, but plaintiffs chose to focus on the impermissible use of sealed records for investigatory purposes. Their complaint is replete with references to the risk of recriminalization if these documents are accessed or used. That's what they chose to focus on. They won a prohibition on the use of those documents.
Go on to the next point,
and
because
we
we
came up with a
understand
meaningful
that
plan.
that is your primary objection, and we understand that. So go on to the other 2 points.
The last point I just wanted to make, Your Honor, is that the police department has recognized the need for a significant change in its practices. We're not looking at the evidence that plaintiffs marshaled or the findings that the Supreme Court made saying there's no issue here. What we are saying is that we came up with a meaningful, tailored approach to the prohibition that plaintiffs asked for and won. These problems.
If we reject that argument, does your plan work at all? If we reject your argument that it has to be limited to investigatory versus non-investigatory, does your plan make any sense anymore?
I think plaintiffs' ask might not make sense, but that's what they chose to litigate. We were directed to come up with a plan.
You're not answering my question, though. You're really not answering the question I'm asking, which is that if we reject your argument about this distinction and we say, no, they're not limited to excising investigation, then what is your objection to the plan?
So if your question is, why can't Supreme Court come up with a grand unified theory for addressing any conceivable use of sealed records? That's not what this case is about, and it just poses too many problems than the more workable plan that we proposed, which was meaningful and tailored to the relief the plaintiffs
Are there
asked
any
for.
more questions before we go on?
Yes, Your Honor.
So one of the points you make in your brief is that paragraph 39 is defective because it renders, it requires that all domestic incident reports be sealed. But that's not what paragraph 39 says at all. It says it requires that NYPD develop and implement modifications to flag a domestic incident report that has become a sealed record. So it seems to me that your complaint that the implementing order calls for a categorical sealing of all domestic incidents report is just wrong relative to what it says. Where is it that I can't find anywhere in the implementing order that says all domestic incident orders are hereby sealed. Instead, it says if a domestic incident report is sealed, the NYPD has to give deference to that. What's wrong with that?
So the problem, I think, comes from the definition of sealed records and information, which is so capacious that it might cover domestic incident reports. And even if you're correct that our characterization is inaccurate, it still begs the question of why is it imposing restrictions if it's not a sealed document in the first instance?
Because it's saying that it only imposes it on if it has become a sealed record. If a judge, in his or her discretion, has decided that a domestic incident report is a sealed record, then NYPD has to treat it in a certain way. That's all it says.
That presupposes that it can become a sealed record. Our argument is that they never become a sealed record for two reasons. One is that the state derives important data from these reports to inform policy and
But if
best
it
practices.
never becomes a sealed record, then this paragraph would be not offensive, but
It says
irrelevant.
we can't disclose sealed information, so if we're flagging it as sealed, we can't disclose all of the information that the state needs.
This paragraph only comes into effect if it is a sealed record. So you're claiming they're never sealed records. So in this case, in that case, paragraph 39 would be surplusage, not offensive.
It's surplus, and we identified how DIR should not be covered at all in the plan on several occasions in the record.
Okay, let's hear from opposing
Thank you.
counsel.
Good afternoon, Your Honors, or maybe good evening, Your Honors. May it please the court, Niji Jain.
Go from the narrow, just because it was just discussed, to the broad, which is the domestic incidents report, since we were just discussing that. Is it superfluous to have that provision? Are domestic reports never supposed to be sealed records?
No, Your Honor. Domestic incident reports, in our view, they do categorically seal. And the language in the injunction says that in the vast majority of cases, they will seal, and therefore it's a...
Where does it say that? It doesn't, not in paragraph 39, which is the only one addressing domestic incident reports.
You're right, Your Honor. It's not in paragraph 39. It's earlier in the paragraph, let me just pull it up, at the beginning of the list of documents that commonly seal. So it is paragraph 14, which says, below are specific records that commonly seal, along with directives for sealing them going forward. And so the way that the injunction is conceived is that at the NYPD's suggestion, there is a list of records that commonly seal with instructions for how to address sealing in those instances. Of course, there will be instances where a DIR
Paragraph
that's...
14 doesn't say that they should all be categorically categorized as sealed reports, does it?
That is true, Your Honor. It says that they commonly seal. So in other words, where a domestic incident report attached to a sealed arrest seals, the NYPD would follow the procedures that are outlined in paragraph 39.
So it modifies paragraph 39. You're saying paragraph 14 modifies paragraph 39?
That's right.
Or explains it?
Right. You could imagine that all of the paragraphs following paragraph 14 are subparagraph A, B, C. It wasn't drafted in that way, but essentially there's a list of specific records that commonly seal, including domestic incident reports, where they are attached to a sealed arrest, and then the injunction provides the specific process for how that would happen.
Paragraph 14 just says that they are commonly sealed. It doesn't direct that all domestic incident reports be sealed, right?
That's correct, Your Honor. Absolutely.
Okay.
Absolutely.
Go ahead. I have a different question. The court's order creates a category of de-identified sealed records. As far as I can tell, the statute doesn't create such a category. So if you agree that I'm right, that the statute doesn't create such a category, why should that part of the court's order stand?
Your Honor, a couple of reasons. First, the Rubenstein case, in the Rubenstein case, the Court of Appeals said that there are a few different sources for exceptions to the sealing statute. Of course, the statutory language itself is most important, but there are other situations where there is a legal mandate that in order to be fulfilled requires unsealing of records, that would be an appropriate situation. But here, we don't have that. We have something that's easier to navigate because on the one hand, we have the sealing statutes which say that sealed records cannot be used against the person that the subject of the arrest. And on the other hand, we have reporting requirements that just require aggregate data to be published in a way that does not implicate the rights of the intended beneficiaries of the statute. And so there is no conflict between those two sets of laws. The only narrow situation in which a conflict would arise is where somebody needs to look through the sealed records in order to compile the aggregate data. And in that very, very narrow instance, the appropriate remedy, the appropriate way to harmonize those competing obligations is through the use of de-identified records.
Why isn't the appropriate way to do that for someone to make an application to a court for permission to look at the record for that purpose?
I think two answers. One is that would be impractical because in order for the NYPD to comply with its reporting obligations, they would need to make an unsealing order for every arrest that that was implicated by any of these various reporting obligations, of which there are many. But secondly, it's because the Court of Appeals case law says that where you have obligations, where you have multiple statutes or multiple laws, regardless of whether they are statutory or local or otherwise, the best reading is to give each of them force and effect.
Was that an issue directly raised by your motion for a preliminary injunction?
Your Honor, actually, it's this is an interesting point.
Could you answer my question?
Apologies. We did not raise that.
Okay.
The defendants raised, the NYPD raised.
But you didn't seek that in your preliminary injunction? In your motion for a preliminary injunction?
That there would be a category of de-identified records?
Yeah.
No, we did not.
Okay. Let me ask you a question. If we were to strike paragraphs 8 through 10 of the implementing order, would that affect the structural integrity otherwise and the functionality of the order otherwise?
No, Your Honor. However, it wouldn't.
Follow up with that while we're still thinking about this. We're talking about the aggregation duties of the city, that they have to aggregate data. If there's no de-identified record, do they then have to do individual requests to comply with their data requirement obligations? I mean, doesn't that become unworkable then on some level?
I don't think so, Your Honor. Two reasons. One, the injunction already says elsewhere that it does not apply to aggregate data. In other words,
so that the city can go ahead and aggregate the data it needs for all its requirements without violating the sealing statute.
As long as they're not doing it in a way where they are accessing individual records. So
how can they do it without accessing individual records? If we were rejecting this idea of the de-identification, and we're saying that's not allowed under the statute, how would they go about accessing this information and this data without looking at individual records? I mean, how are they going to go about and fulfill their obligations on a practical level under the parameters of this plan?
I think the way they would be able to do it is through working with their vendors to program their software in a way that they could do that compilation without.
Has that been discussed on a practical level in terms of the meetings you've had with each other, in terms of whether that is something practical for them to be able to do?
We've not.
I mean, we can't put a requirement on them and tell them they have to be able to aggregate the data because it's required, and then say, but you figure out how to do it, and we don't even know if it's possible. So that's my question, I guess.
Right. I think two things. One, there is some discussion in the papers about the way that the NYPD maintains its databases and the data within those databases, which suggests that it would be possible to program those databases to automatically filter out certain categories. The analogy would be the way that when someone searches the court's ECF, the court's filing system, and says, I only want cases from this date range and from this from the first department or what have you. There's not someone sitting there on the back end, a court staff who's doing some sort of filtering or redacting on the spot, right? The program has been set up to be able to do that automatic filtering, and the NYPD's databases are maintained in a way where similarly they could, through working with their vendors or with their IT department, they ought to be able to do that. And to the extent that
Are there any more questions?
I have one. Oh, go ahead, John. I asked a question already.
So it's almost like an exercise in ready, fire, aim. we're going to commit to a final order and then figure out whether we can implement specific provisions of the order.
Your Honor, the injunction was crafted by the lower court with flexibility and fail-safes. And so there are a number of places where the order says, if this proves unworkable, if this timeline is unworkable, come back. The lower court says, give status updates, work, and it is understood that it is a living document. And because of the breadth of the violations, because of the fact that the NYPD over the past 40 years designed their IT systems in a way that would violate the statutes, it is going to take time to undo those, and it is not possible to answer every question at the outset.
Any further questions? Okay, let's hear from opposing counsel.
So, Your Honors, I think these questions have underscored that even assuming...
Can I ask a specific
Yes, Your
question
Honor.
before you go on? In terms of your aggregation requirements, if we take out this whole de-identification procedure, how is that going to work in terms of your ability to comply or impact your ability to comply with the present plan to comply with your aggregation requirements or reporting requirements?
It still won't work because you can take out the problematic things, but the permission list, the cornerstone of the document, still doesn't allow anyone to create de-identified records or aggregate data.
So is your position that if you take out this provision about the de-identification, that this is not a workable plan in terms of your
You
requirement?
can't just take things out. There are things that need to be added. And by calling it a living document, that just underscores how is the police department
What would need, if you
supposed
took
to know
out
what
the
to do?
de-identification, what would need to be added?
There would need to be access allowed for the creation of de-identified records. It could entail significant logistical hurdles, given that they would need to look at, I don't know how many thousands of records to de-identify them.
So you're in favor of the idea of creating de-identified records?
I think the parties acknowledge that there need
I'm
to
asking,
be
is the city in
competing.
favor of that?
We
Even though it's not required by the statute or permitted?
we should be able to report data and discipline our officers, but the solutions that plaintiffs propose don't sit with
So was it at
easily with the text of the statute.
Was it at the city's instance that that category of de-identified records was created?
No, plaintiffs introduced that. I believe you can see that in their October 21 or maybe it's 22 submission. It was their first proposal where they just imposed a red line on our second proposal.
What specifically would you like us to do?
So because of all the problems that are revealed by these questions, the easiest solution is vacating, reversing, and remanding to give us an opportunity to implement a plan that would be much more manageable, prohibit the use of these records for investigatory purposes as plaintiffs asked.
So what would prevent the city at that point from doing what it did a year ago and publish a report that misuses sealed data in a very public document, which was then touted in a public press release? What would stop you from doing that if we just reverse it? There would then be nothing barring you from doing it except for the decision on the preliminary injunction, which didn't stop you a year ago.
That's not accurate, Your Honor, because since that point in time, we have issued a finest message to all members of service on multiple occasions saying, don't access, use, or disclose these for law enforcement without an unsealing order. Second of all, even Supreme Court found that our mistake was made in good faith and declined to levy sanctions. And third of all, the point acknowledges...
You didn't raise any of that in your reply brief.
I'm sorry, Your Honor?
You didn't address any of that in your reply brief, even though counsel addressed it in their respondent's brief.
I don't believe they did, but just to round out the last point, Your Honor, it just we proposed a change from a rank-based hierarchy to a role-based one, looking at functions that dovetailed with the prohibition on these documents being used for investigatory purposes. And the point is that we can tailor the access problems rather than leaping to this broad, far-reaching order here that poses so many problems.
Thank you.
I have one more question. Just to follow up on what Judge Gesmer said, has Justice Frank had to issue another order reprimanding the NYPD for failing to adhere to his preliminary injunction and the prior order of the other judge who wrote the initial order? Has there been any, since Frank's decision dated March 2 to 2023, has there been any further occasion for the court to reprimand you for similar violation?
Not to my knowledge, and plaintiffs have not identified any violations, to my knowledge.
Thank you.
Any further questions? Thank you very much.
Thank you, Your Honors.
Like this to do? What would you like this to do?
Good job. Congratulations. Nice to meet you.
You too.